can you just make 2 copies of that? Sure. And then 1 to each. Can you give 1 to each party? Thank you. Now you can, yeah.
I bumped up his audio.
You can
just a little.
Sam, go ahead.
I bumped up his audio just a little bit because the people on the end.
I was going to call the case.
Okay.
Do you need something to talk to him for a second?
Yes.
Go ahead. You can turn the audio off for a second.
Sir, good morning.
All right, good morning, everyone. The court will call State of Wisconsin versus Darrell Brooks, case number 21 CF 1848. May I have the appearances, please?
Good morning, Judge Sue Offer, Leslie Basie, and Zach Witchow appearing for the state of Wisconsin.
Good morning, sir. Please state your name for the record.
Just 1 second. Make sure I have everything since they was kind of late today. I'm here as a third-party intervener in that matter, appearing as authorized representative for my client. I accept for value in return for value all of the charging instruments in this matter and make my exemption available for the discharge of all obligations and charges connected with this case. I do not dispute any of the facts in the charging instruments and do not consent to being called that name for the record.
All right, thank you. That is noted. The record will also reflect that the individual known to this court as Darrell Brooks is present in person in custody. He is wearing street clothes, specifically a suit and tie and a mask as well.
And don't consent to being called that name.
I understand, sir. All right, I do want to put on the record I gave the parties this morning. It's an excerpt from a judicial bench book on opening statements. It's about a page and a half. I thought it would be helpful to provide to Mr. Brooks as he puts together his opening statement. It has reference to some Supreme Court rules, SCR, some case law, talks about the manner and purpose, scope, and other things. And as I indicated yesterday, sir, I like to call it the roadmap. It's referred to here as a framework so that the jury can better understand and evaluate evidence. It must also be based on the law and the evidence you believe is properly admissible. I'm going to further advise you at the time when you do make your opening statement that it not reference subject matter jurisdiction. That is, despite what I know you believe to be to the contrary, it is not a requirement to be proven in this case. It is not a factual or legal argument that is accurate, and therefore I'm prohibiting you from referencing that during either opening statements or closing arguments. With that, I believe
For the record, is this the what you're referring to?
The page and a half is from my judicial bench book. I thought it would be helpful to you so that you have a better awareness and understanding of the manner and purpose of an opening statement. This is what guides me as I preside over cases.
Okay, I accept for value in return for value these documents. I don't know why the reference to subject matter jurisdiction in the opening statement. I'm pretty aware that that wouldn't be part of an opening or closing statement. I don't.
Okay, great.
I don't get why that's
I wanted to make the
relevant.
record clear. So I appreciate you indicating to me that you're aware of that.
Even though subject matter jurisdiction has not been proven on the record and should
Sir,
be
it
addressed.
does not need to be proven on the
It-
record. It's established by law and by the fact that, as my written decision indicates, commenced when the criminal complaint was filed in this case. It's conferred by Constitution and by statute.
And who was the complaint filed by? Because subject matter jurisdiction has yet
I'm
to
not
be
going to go
proven
down
on the
this
record.
path today. I'm just advising you, you cannot reference that in your opening statement.
That was something I've already had the common sense to know, but also subject matter jurisdiction has not been proven for the record.
All right, next topic then. I believe the state has
Should be
filed a
proven for the
motion.
record by the prosecution.
Objection is
Alleged.
noted. It is not legally sound. It's overruled.
It's definitely legally sound.
All right,
Has yet to be
Attorney,
proven.
I'm going to turn to Attorney Opper. I believe they filed a motion this morning. Has it been pulled through? I probably just need to refresh, but Madam Clerk.
It was served on Mr. Brooks last night in the jail, Your Honor.
All right, go
I
ahead.
didn't-
You can make. Let me
I
just-
didn't look at the document. I accept the return for value the document. I didn't look at it. So I don't know what I'm supposed to say to that.
All right, well, Attorney Opper, it's your motion. I'll hear from you.
Your Honor, we are moving to amend the information with respect to one word in the entire document. We're asking to change the location of count 76. The information reads as it reads right now. It reads at Frame Park. We're asking to change that to near Frame Park. We believe that that's a more consistent statement that aligns with the testimony of victim PPP, Erica Patterson, as she testified in this trial. We're not asking to change any criminal charges. We're not asking to change any dates. It's, I think, a very small change in the charging document. The defendant has been on notice of the facts of this transaction. It's reflected in a number of police reports and Ms. Patterson's recorded statement, which the defendant has copies of. And so I don't think that there's any grounds for a claim of prejudice by this change, and we're asking to move forward with that amendment to the information.
All right, thank you. Any position on that, sir?
Yes. First of all, for the record, there were originally 2 charges associated with this one party, and these charges have been charged for the better part of a year. I feel that if there was essentially one word that needed to be changed, it's been more than ample time for it to be changed. Even after one of the charges was dismissed, it could have been, that topic could have been visited at that time for it to change. I don't think changing one word at this point really has any bearing on the testimony or the actual charge. I don't understand why a motion needs to be heard about one word. Is I think kind of at this point kind of a moot point. It's been charged like this for a year basically. The language hasn't ever been referenced to being changed before yesterday. So what is the significance of this now at this point?
Thank you, sir. Court is guided by section 971.29 sub 2 of the Wisconsin statutes, which provides at the trial, the court may allow amendment of the complaint, indictment, or information to conform to the proof where such amendment is not prejudicial to the defendant. case law states that when an amendment to the charging document does not change the crime charged, and when the alleged offense is the same and the results from the same transaction, there is no prejudice to the defendant. State versus Wickstrom, 118 Wisconsin 2nd, 339, found at page 348. It's a Court of Appeals case from 1984. And also, I point the parties to State versus Durango, 229 Wisconsin 2nd, 1, and State versus Gerard, 189 Wisconsin 2nd, 505. The first of those two cases is a Court of Appeals case from 1999, and then the second of those referenced is from the Supreme Court from 1995. I'd also point the parties to State versus Frey, 178 Wisconsin 2nd, 729, a Court of Appeals case from 1993. As far as whether this is a moot issue or not, I'll find that it is ripe for determination by this court to hear this motion, and that is because the jury ultimately will be instructed similarly to what the jurors were instructed at the beginning of the case. The charges are read, those are based off of the information, and this proposed amendment does conform to the proof. There is no prejudice to Mr. Brooks. It does not change the charge in any way. It is still the same offense. It's still from the same general information that was indicated in the criminal complaint. So for all of those reasons, I will grant the state's request to amend the information, and the state may file that document as soon as possible.
I have a question about that. So this same person is scheduled to testify again. What if something changes in the testimony?
I'm not going to answer that, sir. It would require me to speculate on what that situation might be and to give an advisory opinion, which I will not do.
But what happens if that happens?
I'm not going to answer that, sir. I can't. You're asking me to give an advisory decision. I'm not going to do that. I'm not allowed to do that, actually. Okay, so we've dealt with that then.
Makes no sense.
The state has not rested yet. Will the state anticipate calling any other witnesses?
Yes, Your Honor, as indicated yesterday, we do intend to recall Detective Casey to the stand, and I'd like to make a record in that regard, please.
Go ahead.
Your Honor, Detective Casey did testify once for the state early in the presentation of the matter. His focus at that point was largely on assisting the jury in understanding the layout of the parade route, giving background and contextual information to the jury on the different parade units that were impacted, what they looked like. We showed several videos with Detective Casey just for background and context purposes. He then went on to describe his personal interaction with the SUV as it came through the intersection of White Rock and Main. And essentially, that was the bulk of his testimony during his first testimony. We're seeking to recall him now. This is not unusual. It is commonly done in cases. We never excused him from his subpoena. We never asked for him to be excused from his subpoena. We always intended to recall him. We did this so that we can efficiently present the information to the jury. The types of questions we have for him now go more to the investigation itself and his role as the lead detective in this case. There will not be duplication or repetitive questions. I'm not going back to the corner of White Rock and Main with Detective Casey during this round of testimony. We want to ask him essentially about how some of the victims along the parade route were identified. We want to ask him about some of the topics that have been addressed throughout the course of the state's case as far as identification of the vehicle and identification of the driver. And we need to still introduce the certified bail forms from Milwaukee County for the 2 bail jumping counts. So he will be asked about that. I estimate my direct examination of Detective Casey would be about 20 minutes. So this is not going to be repetitive. It's information, again, that he has as the lead detective in the case to assist the jury in understanding some of the things on the back end that he was involved in, not his role at the parade. So we are, we have been very efficient in our presentation. I believe Your Honor would agree with that. We're not wasting time here, but we just have a few more questions to wrap this up.
All right, any position from you, sir?
And yes, I do. And I'm gonna start with what was just said. The prosecution feels that they've been efficient in their presentation. So it seems like to me an attempt to get more questions in that could have been asked in the first place. If Your Honor recalls, Detective Casey was testifying for quite some time, to the point that we actually had to have a break before I can cross-examine Detective Casey, if you recall. He was up there quite some time. That was more than enough time for any other foundations to be laid, any questions to be asked at that time. And also, from my recollection, he was asked to be excused. So essentially having him start off and then end it, I feel like it's an attempt to get questions that was maybe forgotten to be asked, answered. And essentially what more could be gained by a second testimony from Detective Casey? What more can be gained that hasn't already been learned? We learned about vehicles and identification by numerous witnesses. We've been through the inspection of the vehicle. We've been through DNA analysis of the vehicle. We've been through numerous things in regards to the vehicle. Even the reconstruction testimony. We've been through all of that. Seems like nothing more than to get extra questions answered that could have been asked from the get-go. As seeing as how he was up there for quite some time and none of those issues were raised at that time. What would be the significance at this point? When it's essentially I should be already presenting my defense at this point in trial. I don't see the relevancy of it, and to my knowledge, he was excused from his subpoena. So,
Thank you, sir.
The relevancy?
Thank you, sir. The court has discretion under 906.11. It's a statute I've quoted with frequency during the course of these proceedings. I've listened to the state's offer of proof. I've listened to the objections made by the defendant. In my discretion, I am going to allow Detective Casey to be recalled for the reasons laid out by the state. As I understand his proposed testimony today, it is not to rehash topics that he was questioned about initially. This has to do with his investigation and role subsequent to the initial contact with Mr. Brooks at the beginning of the parade route. And as the state indicated, we'll address certain things, including identification related to the vehicle, of the driver throughout the investigation, identification of certain victims, In addition, there are 2 additional charges for which the state has not yet presented testimony, so it's proper for those as well. It's relevant, and I will allow it for those reasons. So the state will be able to recall Detective Casey, and we'll have that done, obviously, when the jury is brought out. Any other preliminary issues then from the state?
Your Honor, I am working on going through our list of exhibits, and I will work with your clerk to make sure that everything that I'm showing was admitted and accepted by the court is what she has, so that we can clear that up before we actually rest.
All right, thank you. Anything preliminary from you, sir?
Yeah, just a quick question about that last thing again. I will be able to re-cross-examine,
Oh, yes, you will.
and is essentially anything left off limits to my cross, or what?
I may limit, depending on where we go, if the questions deal with what he testified to previously. It's primarily to cross-examine based on the new testimony. However, 90611 also says this: a witness may be cross-examined on any matter relevant to any issue in the case, including credibility. It does say in the interest of justice, the judge may limit cross-examination with respect to matters not testified to on direct. So I'll give you some leeway, and I'll trust the state will make appropriate objections, and I'll rule on them if and when they're made.
Because I'm not intending to go too much back into the previous testimony, but I think it made a few points from the earlier testimony
I
may
think
come
that's
into
fair.
play, and I just wanted to make sure
I think that's fair.
that wouldn't be a problem.
I think that's fair, sir.
Also, really quick, I did look over some information provided by the prosecution as far as the pretrial offer that I did not have knowledge of until, I don't know if that was today, Thursday. I don't know if that was Monday or Friday or Monday, one of those days. I've put together, started to, I won't say it's completed, that wouldn't be fair to say. I've put together, or started to put together a counter offer, so I just wanted to advise the court that I was putting that together.
All right, thank you, sir. If and when you do provide that to the state, please let me know so we can make a record of that. All right, anything else? If not, then we'll have the jury brought out.
We do have one last large map here, Your Honor, that I'm going to ask to put up and face backwards like we did the other day.
All right, go ahead since the jury's not here.
Got it. Sure. Thank you.
Thank you, everyone. Please be seated, and good morning, ladies and gentlemen of the jury. I know it's a little chilly in here. I'm not sure if that will change now that we're all in here. If at any time that temperature is too cold for you, let me know and we can have that adjusted. All right, Attorney Opper, you may call your next witness.
Thank you, Your Honor. The state would recall Detective Tom Casey.
Good morning, Detective Casey. Please make your way to the witness stand. When you get there, please remain standing. Raise your right hand, and Teresa will swear you in.
Do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you, sir. Please have a seat. Please state your first and last names for the record.
Thomas Casey.
Thank you. Go ahead, Attorney Opper.
Thank you. Detective Casey, I'd like to begin by asking you to refer to the item behind you. There's a large poster board there. If you could please place that on the easel and identify the exhibit number for the court.
It's exhibit number 15.
Thank you. And we've had testimony about this exhibit throughout the trial. Is that right, sir?
Yes, we have.
All right. Your role in this case was what, sir?
Objection, leading.
Overruled.
Initially, I was on traffic control for the parade. Shortly after the incident happened, I was assigned as lead detective for the case.
Were you the individual who created this map, State's Exhibit number 15?
Yes, I did.
Okay. And I would like you to talk a little bit about how victims were identified in this case.
Objection, leading.
Overruled. Foundational. The witness may answer.
So at least initially, can you tell us, like, in the day or two after the parade, what happened?
Objection, leading.
Overruled. You may answer.
So initially, that night, we knew that the victims were taken to different hospitals around the area, generally 5 different hospitals. So at the beginning, we began by having detectives assigned to each hospital. Waukesha Memorial Hospital received the most patients, so they also had a lieutenant that was assigned there as a team leader. As the patients came in, they were identified by detectives. The hospitals also provided us with a list of patients that they had, and we went through those lists and tried to identify people that came in and were being treated.
And then eventually, were there follow-up interviews conducted with these individuals?
Yes, there were.
What if the individual was a person under the age of 18?
Objection, leading.
Overruled. You may answer.
If the person was a minor under 18, then we would reach out to their parents, talk to the parents. Some of the kids were able to talk to us, but we got the majority of their statement from their parents.
Okay. And do you believe that the names on Exhibit 15 truly reflect all the injured victims that you were able to identify in the course of this investigation, sir?
Objection, speculative.
No, I do not.
Hold on. There's been an objection. It's overruled, and the witness will repeat his answer.
No, I do not.
Can you explain that?
Objection, leading.
Overruled.
Just because of the scope of the investigation, we had so many people that were hurt, we had to come up with some kind of parameters to limit the people that we would call victims. One of those parameters is that they had to receive treatment at a hospital. Another one is that they had to be in the street when their injuries occurred. So there are some people that were injured, maybe on the sidewalk, trampled by the crowd, or received injuries that they didn't get hospital care from. You know, and unfortunately I learned later on there was even a person that was in the band that somehow we missed her being reported that she received a broken leg. So there are some that are not on the map, but all the people that have been charged are on the map.
So you mentioned people on the sidewalk. We did have some spectators testify in the trial, correct?
Objection, leading.
Overruled. Foundational.
Correct, but they were more in the roadway or on the curb, not on the sidewalk, or not running away from the incident when it happened.
I see. So was, in your mind, when you were leading this investigation, trying to identify victims, what was the importance of the SUV in the injuries that were caused?
Objection, leading.
Sustained as to the form of the question. Please rephrase.
Why were the spectators that are on this map included?
Because they were directly contacted by the SUV that came down the street.
If a person were injured because they were trampled by the crowd, are they on this map?
We
Objection,
exclude those.
speculative.
Overruled, the detective may answer.
Those people were excluded from the map.
There were some people like that, right?
Yes, there
Objection,
were.
leading.
Okay.
Please make
Sorry.
sure.
I
Thank
know.
you. I'll allow his answer to stand. Next question.
All right. I'd like to put up for you exhibit number 32, which has been previously identified. I'm sorry, admitted.
I'm sorry, you said 32?
Yes.
You said
Yes.
32? Okay, thank you. Sorry, I just missed it. Just to the witness or published, because it's been received.
Yes, we are going to publish this, Your Honor.
Go ahead.
But I
Permission
do-
granted.
Okay, thank you. And while we're waiting for it to come up in the jury box,
I don't have it on my screen.
It may take a second. Hold on. If it's not, let's check the cables.
We don't have it
Yeah.
either.
I can see it. The witness can see it. Go out it. Thank you for letting us know, sir.
it's just the front tables, back tables on, Your Honor.
Hold on. I'm gonna stop source for a second. I know. Anything? Yeah. You can see it on the screen though, right, sir? On the, there's screen, obviously, on the far side of the courtroom and then to your right.
It's always better on here because
I understand. We'll get our tech guy over here to look at it, but it's previously been received and we can see it on the two other monitors. So for now, we're gonna continue. If there's anything new, I'll make sure to pause. Go ahead.
Detective Casey, I want to focus your attention specifically as to the extreme dance team. We heard testimony about several of the girls on the team being struck and injured. Do you remember that testimony, sir?
Yes, I do.
leading.
Overruled, it's foundational. The answer may stand.
Do you know if there were other people associated with the extreme dance team that were injured?
Objection, speculative.
Overruled, he may answer.
Yes, I do.
And do you know the names of these people?
Objection, hearsay.
Overruled, he may answer.
Yes, I do.
What were their names, please?
Kathleen
Objection.
Pellmeyer.
Speculation.
Overruled, he may answer.
Go ahead, sir.
Kathleen Pellmeyer, Jennifer Stover, and Mitchell Lampine.
What was their role with the dance team?
Go ahead.
Jennifer and Kathleen were support people. Jennifer's daughter was marching the parade. And then Mitchell was there to hand out candy with his stepmom.
Okay. I'm gonna now play, it's still not being displayed on our tables, Your Honor, but it is displayed on the two large monitors in the courtroom. So do I have permission to proceed?
Which exhibit?
This is 32.
Oh, yes. If we get to a new one that hasn't previously been received, then I
Yes,
will
okay.
pause to get
All
the
right.
tech people in.
All right. And
Go ahead.
Objection
Bailiff.
to relevancy.
Overruled.
The bailiff confirmed it's on in the jury box, Your Honor.
Thank you.
All right, please play. From the 32-second mark, I'm sorry, 35-second mark to 47 seconds.
How long is the exhibit?
Looks like it's 1:23 according to what I can see on my monitor.
Definitely.
It is 123 total. We're only playing this 12-second clip from 35 to 47.
Thank you.
And please pause. Do you see any of the individuals you were just testifying about enter the screen, sir?
Objection, speculative.
Overruled. He may answer.
Yes, I do.
Could you identify them by using the touchscreen?
Objection, leading.
Overruled. He may answer.
I'm gonna draw one big circle.
Okay,
It has two individuals. It has Jennifer and Kathleen. Kathleen has the red jacket on, and directly to her left would be Jennifer in a black jacket.
okay. A little hard to see right now, but as
Yeah,
they,
it's very hard to see.
as they
Keep
walk,
going.
could you see two people walking there, sir?
Yes, ma'am.
Okay. Please clear the screen and continue playing. And pause. And I'm sorry, because I can't see the counter, Your Honor.
It is at 44 seconds.
44 seconds, thank you. Paused at 44. Do you see anybody else that you just testified to in the video at this point, sir?
Objection, speculation.
Overruled. He may answer.
Yes, I do.
And who is that?
Leading.
Mitchell.
Objection.
Overruled.
Mitchell Lampine.
Please circle Mitchell. Do you know Mitchell's approximate age?
Objection, speculative.
Overruled.
I believe he's about 10.
Okay. All right, we can take down 32. Did, this video goes on to show the red SUV drive through the extreme dance team, correct?
Objection, leading.
It's foundational. Your Honor.
Overruled. It's foundational. It's previously been received. Go ahead.
Yes, it does.
To your knowledge of this video, sir, did those individuals, Mitchell and Ms. Stover and Ms. Pellmeyer, remain along the left side of the road there as the SUV went through?
Objection, leading.
Overruled. The witness may answer.
They were hit by the vehicle and then moved to the left.
Let's take a pause for a second. We
Yes.
have our IT experts. Hopefully they can get this figured out.
Yeah, I just turned off the sign.
It's a lot of pressure.
Go ahead.
Could you put something on the screen that's okay to you for the moment?
Next one will be 132 if you want to. No, I'm sorry, 55.
It's on our screen.
It's on now.
Hold
got
on,
it.
let's make sure. Do you have it now, sir?
Yeah.
Yes?
Yes.
Oh, good, great. It's on mine, it's on the witness.
Do they have it too?
All right.
Just
Thank
like
you.
real life. You call the help desk and they show up and now it works, yeah.
Like when your car's making noise, right?
Jury monitors, we're working. It's not, hold on, let's make sure. It was just working. There's a delay.
Well, maybe next time I'll just take this down, the whole, take it down, the whole thing back on me.
Are they still off?
Sometimes they take like.
It can take 30 seconds.
What exhibit is this one?
This is 55.
All right, it's not. Very good. We're up and working. And 55's previously been received, so go ahead.
All right.
Objection to the relevancy of 55.
Noted, overruled. Go ahead, Attorney Alper.
Detective Casey, Exhibit 55, can you see at the end of the road there, or the top of the screen, what unit is involved in Exhibit 55, please?
Yes.
Please tell us.
Objection, leading.
Overruled.
It is the dancing grannies that are approaching from the right.
Okay. And one of the dancers, we have her testimony that was involved with the grannies was a woman by the name of Lola Hospital. Is that correct?
Objection, leading.
Overruled. It's foundational. The witness may answer.
Yes, she was.
Is there video showing Miss Hospital being struck by the SUV?
Objection, leading.
Sustained as to the form of the question. Please rephrase.
Sure. Is the exhibit, you've seen Exhibit 55 before?
Yes, I have.
Are you able to identify Miss Hospital, yes, Lola Hospital in Exhibit 55, sir?
Objection, leading.
Overruled.
Yes, I am.
All right. We're going to play the clip, Your Honor, from from 4 seconds to 8 seconds at 50% speed, and it is zoomed in on the middle of the road where the Dancing Grannies are located.
All right, go ahead, thank you.
Please describe for the jury what you just saw in the video, sir.
Objection leading.
Overruled.
I saw the red SUV driving westbound on Main Street, approaching the Dancing Grannies and hitting Lola Hospital and then striking 2 other Dancing Grannies.
When you say hitting Lola Hospital, what did you see?
Objection leading.
Overruled. You may answer.
I saw the left side of the car come in contact with her, and then her body moved to her left after.
Did Ms. Hospital report any injuries to the Waukesha Police Department?
Objection leading.
Overruled. The witness may answer.
Yes, she did.
All right, sir. I'd like to now ask that Exhibit 118 be published for the jury. This has previously been admitted.
Permission granted.
Objection to the relevancy of 118.
It's previously been received. Go ahead.
Sir, do you recognize the item shown in Exhibit 118?
Yes, I do.
And in addition to the photograph, have you had an opportunity to examine that item or items
Objection leading.
personally?
Overruled. The witness may answer.
Yes, I have.
And Mr. Johnson from the crime lab testified about these items yesterday, but I'd like you to tell the jury what you remember of these items, please.
Objection leading. Affirmative. The first part of the question.
Overruled. The witness may answer.
So this is the red SUV that was used in the parade attack. This is a picture of it taken after. I remember a hood from a white jacket and a hat, a black hat with snowflakes on it, being pressed in between the hood and the windshield wiper of the vehicle.
Objection to it being called an attack. I think that's a disparaging remark for the record.
Your objection is noted, and the answer will stand. I will instruct the witness to simply describe what he is seeing without further characterizing it, as it will be up to the jury to determine the facts in this case. Go ahead.
Thank you. When you saw these items on the hood of the red SUV, did you later come to recognize where they may have come from?
Objection leading.
Overruled. The witness may answer.
Yes, I did.
What did you determine?
I determined that they were the jacket, hood, and hat that Virginia Sorensen was wearing while she was walking in the parade.
Like to display to the witness only, please, Exhibit 177. This has not yet been received, Your Honor.
All right, go ahead, please.
Is 177 on your screen, sir?
Yes, it is.
And what do you see in Exhibit 177?
Objection leading.
Overruled.
I see 2 dancing grannies carrying a Milwaukee Dancing Granny sign, and the woman on the left is Virginia Sorensen, and she's wearing a black hat with snowflakes, wearing a white jacket with a hood on it.
Move to admit 177 and permission to publish, Your Honor.
Objection to the relevancy.
The objection is overruled. Exhibit 177 is received. Permission to publish is granted.
Said 177?
177, yes. And if the jurors would let me know when it's in the jury box as well, please. All right, thank you, it's there.
And again, just so we're clear on the record, please circle Virginia Sorensen in the hat in this picture.
Objection, leading.
Overruled.
That is Virginia, and then this would be the hat and hood that I believe was found on the SUV.
Okay. Detective Casey, there were many videos that have been shown to this jury, correct?
Objection, leading.
It's foundational, Your Honor?
Overruled, the witness may answer.
Yes, there have been.
To your knowledge, are there any videos that display the license plate of the red SUV as it goes along the parade route?
Objection, leading.
Overruled.
Yes, there are.
Is it possible to capture a screenshot from those videos to see the license plate of the red SUV along the parade route?
Yes, there are.
I'd like to display for the witness only, Exhibit 150.
Go ahead.
Is 150 on your screen, Detective?
Not yet.
Okay,
It is now.
all right. Do you see Exhibit 150?
Yes, I do.
Please describe what you see in Exhibit 150.
Objection, leading.
Overruled.
I see the red SUV that was driven through the parade route, and it's at the time when it was contacting the Waukesha South band members. In that photo, you can read the license plate number.
Do you believe this photo is a true and accurate representation of the events of the day?
Yes, I do.
Move to omit 150 and permission to publish.
Objection. How does this go to investigation? Exhibits
Overruled.
on investigation.
Exhibit 150 is received. Permission to publish is granted.
The image is a little blurry, correct?
A tad.
Can you please point out the license plates in the photo and read it for the jury?
Is it okay if I circle it?
Yes.
Overruled, you may do so.
That is the license plate number, and I read ADP 9256.
All right. Now I'd like to show to the witness only number 151, please.
Go ahead.
Please describe 151. Oh, please clear the screen, Madam Clerk.
This photo is of the red SUV on the parade route. It's just photo taken just prior to the Barris Logistics float, and the band director is in the lower left-hand side of the video. It shows the red SUV with the license plate number displayed.
Do you believe this photo represents a true and accurate depiction of the events of the day?
Yes, I do.
Move to admit 151 and permission to publish, Your Honor.
Objection to relevancy.
Exhibit 151 is received. Permission to publish granted. The objections noted and overruled.
I recall this state saying they had 140 exhibits. How did we get this many?
Keep going, Attorney Yopper.
Detective, please describe what you see in 151. I think you did describe it. Strike that. Please circle the license plate and read it for the jury.
Objection, leading.
Overruled.
ADP 9256.
Thank you. It's still not up. Okay, I'm sorry. Gotta wait for the jury.
Go ahead.
Detective Casey, during your investigation, did you uncover any other videos linking Mr. Brooks to this same vehicle with this same license plate?
Objection, I don't consent to being called that name and it's leading the witness.
Overruled as to both counts. You may answer.
Yes, we have.
Could you describe this video for us, please?
Objection, leading.
Overruled.
There's a video that we obtained from social media that shows Mr. Brooks standing next to the SUV, and you can clearly see the license plate number on the vehicle. I believe the video was taken sometime prior to November 21st, 2021.
Okay, I'd like to display for the witness only Exhibit 175, please.
Go ahead.
Please identify 175.
This is
Objection. Relevancy.
Overruled. You may answer.
This is a photo. There's two individuals in the photo. The individual on the left, I know to be the person referred to as Darrell Brooks. It displays a vehicle, a red Ford, and it has the license plate number, which is displayed in the photo.
What is the source of this photo?
Objection, leading.
Overruled. The witness may answer.
We obtained it through social media.
Okay. I mean, this is a photo versus a video.
This is the photo taken from
Hold
a
on.
video.
I understand the objection. It's sustained. It's foundational. This particular question, the witness may answer. Go ahead.
This is
Overruled or sustain?
Overruled.
You said sustain.
What did I say?
Yes, you did.
Sorry. I meant it's overruled. The witness may answer. Sorry. I'm taking notes. I was writing the word source, and I think that's why I did that. In any event, go ahead and answer. Sorry about that for any confusion I may have caused.
This is a screenshot taken from a video.
Move to admit 175 and permission to publish, Your Honor.
Objection to that. What's the relevancy? I don't see the alleged defendant in here.
Your objection is noted. It is overruled, and Exhibit 175 is received. Permission to publish is granted.
Sorry.
The jury would also let me know when it's in the jury box monitors or on the jury box monitors. All right, go ahead.
Detective Casey, is person you know as Darrell Brooks in this photograph?
Objection, I don't consent to being called that name and leading the witness.
Overruled. The witness may answer.
Yes, he is.
Please circle or X or mark in some fashion. How do you know that's Darrell Brooks there? His back is to us.
Objection, leading.
Overruled.
I've watched the video in its entirety and I have seen his face in the video.
Okay, that can go down, please. Detective Casey, in total, how many videos do you think were collected by the Waukesha Police Department during this investigation?
Objection, speculative.
Overruled. He may answer.
We have at least 65 to 75 files. Some of those files contain multiple videos, photos, could be 10 each, so I would say probably 300 to 400 videos we've collected.
What were the source of those videos?
Some of the videos came from different people that were at the parade. Some of them are from city-owned cameras, and some of them are from fixed surveillance systems from businesses that were in downtown Waukesha.
Were all of the videos that were available shown to this jury?
No, we're not.
Objection, leading.
Overruled. You may answer.
No, they were not.
Have you personally observed and reviewed each of the video files available in this case, sir?
Objection, speculative.
Overruled. You may answer.
Yes, I have.
To your knowledge, sir, did any video ever show a different person behind the driver's wheel of that red SUV?
Objection, leading.
Overruled. The witness may answer.
I have never seen anyone driving the vehicle besides the defendant in any of the videos that I looked at.
In any of the videos, were you ever able to see multiple people inside the vehicle?
Objection, speculative.
Overruled. The witness may answer.
None of the videos that we have looked at showed anyone else in the vehicle.
Do any of the videos at any point show the red SUV coming to a stop, a complete stop along the parade route?
Objection, leading and speculative.
Overruled. The witness may answer.
I've never seen a video that shows the vehicle slowing or stopping while it was on the parade route.
Do any of the videos show the driver of the vehicle exit the vehicle to check on a person who had just been struck by the vehicle?
Objection, leading.
Overruled. The witness may answer.
I never observed in the videos the driver of the vehicle to stop and check or exit the vehicle on anyone.
There was testimony earlier in this case about witnesses observing multiple people running from the car. Do you remember that?
Objection, leading.
Overruled. The witness may answer.
Yes, I remember that.
Were there multiple reports like that, sir?
Initially, there were some reports like that.
When the vehicle was found on Maple Street, you weren't there.
Correct.
Objection, leading.
Overruled. His answer may stand.
Do you know what police activity occurred when the vehicle was found on Maple?
Objection, speculative. He just stated he wasn't there.
Overruled. The witness may answer. He was asked, what does he know?
Yes, I do.
Please tell the jury what happened when the SUV was found on Maple.
Objection, leading.
Overruled. The witness may answer.
Initially, Officer Moss went, he secured the vehicle, did not find anybody in the vehicle. There was an initial report that saw some other people running from the area of the vehicle. After that information was given back to us, we sent detectives down to the area to investigate further to see if we could corroborate and find out if that was true or not.
After that investigation, did you have other suspects or just one person?
Objection, leading.
Overruled. The witness may answer.
Based on the information of what everybody saw on the parade route, and then the detectives that went back down to Maple Avenue where it interviewed the people that reported the people running, our investigation determined that there was only one person in the vehicle and there was no other suspects that we were looking for.
At some point in your investigation, Detective Casey, were you given a Ford key?
Objection, leading.
Overruled. The witness may answer.
Yes, I was.
What was your understanding as to the source of that key?
My understanding that that key was taken from Mr. Brooks when he was taken into custody and turned over to Detective Stern and Detective Carpenter.
Objection, I don't consent to being called that name for the record.
Noted. Overruled.
How did you get it?
Objection, leading.
Overruled. The witness may answer.
You just stated how you got it.
Overruled. He may answer.
Detective Stern brought me the key the morning after the incident.
Did you do anything with the key?
Yes, I did.
Tell the jury what you did, please.
Objection, leading.
Overruled.
At that point, the vehicle was at the Waukesha County Sheriff's Department Secure Storage Facility. Mr. Johnson was over there processing the vehicle. I went there and I took the key with me and I checked the vehicle to see if the key would work in the car.
What did you find?
Objection, leading.
Overruled.
I found that the key worked the door locks to unlock the car. I also put the key in the ignition and it turned the ignition lock.
Thank you. Detective Casey, you've heard testimony about the manner in which the defendant was identified by the name of Darrell Brooks. Do you recall that testimony, sir?
Objection, I don't consent to being called that name, misleading the witness.
Overruled. Foundational. The witness may answer.
Yes, I do.
Did you endeavor to verify the identification of the subject you had arrested for this incident?
Objection, leading.
Overruled.
Yes, I have.
Did you verify his identity by the name of Darrell Brooks?
Objection, I don't consent to being called that name, leading.
Overruled. The witness may answer.
Yes, I have.
How did you do that?
Objection, leading.
Overruled.
There were a couple different ways. One way is when a person is taken into custody, we take their fingerprints. We check that against other records that are kept by the state. Those fingerprints matched Darrell Brooks. I've also spoken to 3 women that he has children with. They verify that is his name that he has always gone by. I have also spoken to his mother, which states that that's the name that he has gone by always.
I'd like to put on the screen for the witness only Exhibit 88.
Go ahead.
Do you see Exhibit 88, sir?
Yes, I do.
Objection to this, what's the relevancy?
Overruled. Go
Can you-
ahead.
Grounds for overrule.
Relevant.
In what way is it relevant?
Two of the counts alleged in this case. Go ahead.
Can you please identify Exhibit 88, sir?
This is a bail bond through Milwaukee County Circuit Court for Darrell Edward Brooks, the date of birth of 2/21/82.
To your knowledge, was Mr. Brooks on bail through a Milwaukee County case on the date of November 21, 2021?
Objection, leading.
Overruled. The witness may answer.
Yes, he was.
And what is the date of this bail form, please? I believe it's near the bottom.
The date on the bottom
Objection,
is
leading.
Overruled. The witness may answer.
2/21 of 2021.
Was Mr., we'll strike that. By classification, can you tell us the level of charges that Mr. Brooks was pending on for this bail?
Objection. We've already made a ruling on it.
Overruled. The witness may answer.
All the charges that I see on here are felonies.
To your knowledge, was this bail in full force and effect on November 21 of 2021, sir?
Objection.
Overruled. You may answer.
Yes, it was.
And in the middle of the form, do you see the conditions of bail that were set upon Mr. Brooks?
Objection, leading.
Overruled.
Yes, I do.
And I'm looking under paragraph B, the third bullet. Do you see that?
Yes, I do.
Could you please read that bail condition to the jury?
Objection, leading.
Overruled. The witness may answer.
The state defendant shall not commit any crime.
Thank you. Move to admit number 88, Your Honor.
Objection.
Exhibit 88 is received.
Like to display for
It was
the.
already speculated to. How's that coming into evidence?
Overruled and permission to publish.
I'm sorry, I did not seek to publish this, Your
Oh,
Honor.
all right, turn that
I
on.
request a legal finding of fact for that.
The objection is noted. It's overruled. Continue. Attorney Opper.
Thank you. I'd like to display for the witness only Exhibit 89.
Go ahead.
Sir, can you please identify 89?
Objection.
Overruled.
Relevancy.
Overruled.
This is
This has been speculated, stipulated to as well. How's it evidence? How's it being admitted?
The objection's noted. It's overruled. The witness may answer.
I request a legal finding of fact for that too, Your Honor.
Noted. Overruled. Go ahead.
This is a bail bond through Milwaukee County Circuit Court for Darrell Edward Brooks with the date of birth of 2/21 of 1982.
Is this a different case than what was displayed in Exhibit 88?
Objection leading.
Overruled.
Yes, it is.
Are you able to make any observations about the level of charges related to this case, sir?
Objection leading.
Overruled.
It appears that there's 4 charges, 2 of which are felonies.
Okay. And on the bottom of the form, can you tell the date that this bail was issued?
Objection leading.
Overruled.
States 11/11 of 2021.
The directing your attention again to that same location in the middle of the page under paragraph B, the 3rd bullet. Could you please read the conditions of release that were set by the court in that case?
Objection leading.
Overruled. The witness may answer.
Defendant shall not commit any crime.
To your knowledge, sir, was this bail in full force and effect on November 21 of 21?
Objection speculative and leading.
Overruled as to both. The witness may answer.
Yes, it was.
Finally, sir, I'd like to put up one last item for you, or 2 items. 1 second, please. I'd like to display for the witness only Exhibit 13.
Objection. What's the relevancy of this? How does it say any foundation to testimony?
I'll give the state some leeway to establish that. Go ahead.
Thank you. Sir, do you recognize can you tell if Exhibit 13 is a video, sir?
Yes, it is.
Okay. Have you seen this video before, sir?
Objection leading.
Overruled.
Still relevancy. Where's the relevancy?
The state is asking the foundational questions. The objection's a bit premature. I'll take it under advisement. Go ahead, Attorney Opper.
Yes, I have.
What does this video depict?
Objection leading.
Overruled. The witness may answer.
Objection speculative.
Overruled. Go ahead.
This video depicts the backyard at 4014 North 19th Street in the city of Milwaukee. It also, that's the address of Dawn Woods, the mother of Darrell Brooks. And on the lower left-hand corner, you can see a Ford Escape.
In the lower
Objection.
right.
I move to strike that. How does he know? What?
The objection's noted. Overruled. You can ask him on cross-examination. You can question him about that. Go ahead.
In the bottom right-hand corner of the exhibit, do you see a date and time stamp for this video, sir?
Objection leading.
Overruled.
Yes, I do.
What does it say?
It says 11/21-2021, and then it says 13:26:18.
What do those numbers represent, sir?
Objection leading.
Overruled.
To me, it'd mean that the video was taken on November 21st, 2021 at 1:26 p.m.
And do you believe this video is a true and accurate representation of the events of that afternoon at that location, sir?
Objection, speculative.
Sustained, if you could lay a little more foundation,
Sure.
please.
How did you come into possession of this video, sir?
The defendant's mother provided it to us.
And do you know approximately when it was obtained?
Objection, speculative.
Overruled.
The evening of November 21st, 2021.
Do you know if the defendant's mother was cooperative with police in providing the video?
Objection, relevancy.
Overruled. The witness may answer.
Yes, she was.
Do you know if the video was provided to police when asked?
Objection, leading.
Overruled.
Yes, it was.
Do you have any reason to believe that the video was altered or modified in any way before it was provided to police?
I do not.
Move to admit 13, Your Honor, and permission to publish.
Objection, relevancy.
Noted. Overruled. Exhibit 13 is received. Permission to publish is granted.
For the record, this is a video. It's 49 seconds in duration. We're going to play it in full. There is no audio, and it will be played at normal speed. Oh, hang on, don't play yet.
Yes, if the jurors would let me know when the monitors are displaying the video. All right, go ahead.
Detective Casey, were you able to see any emblem on the front grille of that vehicle as it drove away?
I would have to look at it again.
Okay, I'm sorry. Let me ask you this. Did you see any damage to the front end of that vehicle as it drove away?
Objection, leading.
Overruled.
I did not.
Okay. I'm going to put up State's Exhibit 14 now, please.
Go ahead. Just to the,
Yeah, just to the witness only, please.
thank you.
Do you recognize Exhibit 14, sir?
Yes, I do.
What is the source of Exhibit 14?
This is a still shot taken from the video.
The same video we just saw, number 13.
Yes.
Okay. Move to admit 14 and permission to publish, Your Honor.
Objection, relevancy.
The objection's overruled. Exhibit 14 is received. Permission to publish is granted.
Sir, do you see Darrell Brooks in this photograph?
Objection, I don't consent to being called that name again for the record.
Noted. Overruled.
Yes, I do.
Can you identify or, describe the clothing items that you see him wearing in this photograph? Oh, it's not in the jury box yet, I'm sorry.
You can state your objection, though.
Leading.
Overruled. The witness may answer.
Mr. Brooks is wearing a red t-shirt, blue jeans, and he has blue colored flip flops on with white socks.
And what's the date and time stamp for this photograph, please?
It's 11/21/2021 at 13:26:08 hours.
And that's what time, sir?
Objection leading.
On the 12-hour clock.
Objection leading.
Overruled.
That would be 1:26 p.m.
All right, thank you. I don't have any other questions, sir?
Lee Cross.
In the two exhibits we just watched, 13 and 14, do you see anyone driving the vehicle?
No, I do not.
Do you know if anyone's in the vehicle at the time that you see it pull away?
I would assume, based on my training experience, that when the vehicle pulled away, that there was someone inside the vehicle, because in order to move a vehicle, you have to manipulate the controls, the shifter, the brake, the accelerator. So my assumption is that someone is inside the vehicle doing that.
That wasn't the question. Do you see anyone in the vehicle?
I object, Your Honor, that was the question, and he's already asked and answered. The question is, anyone can be seen.
The objections, not sure what the objection was, but the answer may stand. You can ask your next question.
Let's go back to Exhibit 175. Can you pull that up for the witness?
Would the state please pull that up? Witness only or published?
Published.
Okay, thank you. Go ahead. Jurors, let me know when it's in the jury box as well. All right,
Just-
go ahead. It's in the jury
You
box.
just testified that this was the alleged defendant. How do you know that? Can you see a face?
Which question are you asking? Those were two.
Can you see the face on the circled individual in that exhibit?
In this clip, I cannot see the face of the person that is circled.
So how do you know who it is?
I can tell who that is because I have watched this video in its entirety, and I can tell that it is you based on all of my contacts with you.
So why were there not any other exhibits that can give credibility to you positively identifying the individual in this video?
Objection, argumentative,
Grounds.
compound.
Sustained as to the form of the question.
Is it fair to say that this is the only exhibit photo from the video?
Go
Can
ahead.
you clarify the only one that is shown today, or the only one that has ever been taken?
The only one
that
that's
ever
the only
exists?
one that's
Could you clarify,
being
please?
shown right here today. Is this the only one that is an exhibit being shown here today?
Yes, this is the only one that we've shown today.
And you can tell just from this exhibit exactly who that individual is.
I don't believe that was my testimony.
I'm asking the question.
From just looking at this, no, but I know from looking at the entire video that it's you.
We're talking about this exhibit that's being shown right now during your testimony right now at this moment. Strictly that.
Could you ask your
Objection.
question, please?
I'm going to object, asked and answered.
Sustained as to the form of the question as well.
Would it be fair to say that from this exhibit 175 that they're looking at right now, that you cannot tell who the circle individual is? Would that be fair to say?
That would be fair to say.
Can you clear the circle?
Thank you, Madam Clerk.
And do you recall what date you viewed this video, as you call it?
I have viewed this video multiple times. I don't recall the specific dates that I have seen it.
Was it relatively early on in the investigation?
There have been multiple times that I've watched this video. Some of them early, some of them as late as yesterday.
Do you recall seeing this video the same night of the incident or in the days following?
I did not see it the night of, but it would be the days following that I have seen it.
And at that time, did you have knowledge of who that vehicle belonged to?
Yes, I did.
And did you have knowledge of the usage of that video? The usage of that vehicle?
I'm not sure that I understand the question.
Did you have knowledge of who may have been using the vehicle?
Objection vague as to time.
Sustained as to the form of the question, if you could limit, or perhaps direct him to a specific time frame regarding the use of the vehicle.
At the time of the incident?
Yes.
And can you clear that? And what information was that?
The information that I had is at the night of the incident that you, Darrell Brooks, were the person that were operating the vehicle.
And who did you learn that from? And for the record, I don't consent to that name.
Noted,
For the record.
overruled. Go ahead and answer.
Can you repeat your question, please?
I'm gonna go another route on this.
Are you done with the exhibit, sir?
No, I'm not.
So you're withdrawing your question?
Yeah, I'm going another route.
All right, thank you.
You just testified to seeing the entire video that this steel frame exhibit came from, correct?
I testified that this came from the entire video, correct?
You said that you viewed the video in its entirety, correct?
The entirety, what we recovered from your social media account. I'm not sure if there is a longer version someplace, but
Did you see the video in its entirety? The video that this exhibit came from?
yes.
And are these the only two individuals that you observed in that video?
They are the only two that I recall seeing in the video.
Did you ever inquire about the identity of this individual?
No, I have not.
Can you clear that circle?
Thank you, Madam Clerk.
Would it be fair to say that from looking strictly at the exhibit that we're viewing right now, that both individuals have the same hairstyle?
It would be fair to say.
Can we clear the X's and clear the exhibit?
Go ahead. Thank you.
We go back to Exhibit 13, published.
Go ahead. The state would assist, please.
13. Can you play it
Well, just play it. I'll tell you when to pause if that's okay.
Go ahead.
It's not up yet.
Oh, thank you. We're gonna wait till it's in the jury box.
Okay.
Okay, go ahead, thank you. Just as a reminder, it's 49 seconds long.
I don't think I'm gonna need the. Well, I don't know. Yeah, I might. Pause. Right there, the individual that you observe. Right here. Do you see them wearing a hoodie?
The person in that photo is not wearing a hoodie.
Do you see a hoodie anywhere present in this video?
No, I don't see a video or a hoodie anywhere in the video.
Can you take the X down? From this angle, it'd be fair to say that you can see the very front end of a vehicle, correct?
That is correct.
Can you see any windows or see inside the vehicle at that time? Or at the time that we're looking at right now?
You cannot see inside the vehicle at this time.
So it would be fair to say that just by looking at what we're looking at now, you wouldn't know if anyone's already inside the vehicle.
This has been asked and answered, Your Honor.
I'll allow it, the witness may answer.
This is a whole different.
I'm allowing it. Go ahead.
That is correct. From this video, you cannot tell if anyone else is inside the vehicle.
So it would be fair to say that you're not sure.
It's fair to say that I am not sure.
Can we pull this down? Whoa, wait. I'm sorry. Can you pull that back up for 1 second?
Same exhibit.
Same
Go
exhibit,
ahead.
13.
All right. The state would put that
Ju-
back
right.
on display,
It does-
and there you go.
The-
Do you want any
wait.
more of a plate or just the still?
We waiting for the jury, or do they?
It's up.
No, we don't need it played.
Do you need it to go to a certain point?
Yes,
All right, do you know what point?
I'm about to it right now. Looking at this house right here, do you see an address posted anywhere on this house?
In the photo that you circled, no.
So it'd be fair to say that you don't know the address of this house.
That is incorrect.
You just said that you don't see an address posted anywhere in this house. So from the vehicle, strike that, not the vehicle. I'm still looking in the corner right here. From the video that we're viewing right now, do you see an address posted anywhere on this house?
I do not see an address posted in this photo.
So judging by this, well, actually it's a video, but judging by this video, how can you know the address of this house?
Because I've been at this house before to talk with your mother. I've seen the address on the front of the house.
Judging by this video.
Hold on, you have to let him finish, because that was not the question you asked. You asked him how he knew. He can answer. Go ahead, Detective Casey.
I have been at this address before. I have spoken to your mother. I have been in the backyard of the residence. I've seen the address on the front of the house. I know this to be your mother's house. I recognize from this photo to be your mother's address at 4014 North 19th Street.
You recognize the house or the address? Because we don't see an address in this video.
I recognize this house to be that address from being there.
And had you already been there, as you say, and talked to people, as you say, before you viewed this video?
I believe that I saw the video first, and then I was at the address.
So at the time that you saw this video, you didn't know whose house that was?
That would be an incorrect statement.
You just said that you saw the video first before going to the house. Did you, or did you not say that? Would that be fair to say?
I guess I'm a little confused in your question. We received the video. We know from getting it from my mother that she said that that is where she lives. So I knew that this was where she lives when I watched the video. If that helps clarify for you.
I follow you, but that clarification wasn't stated before. So that's fair from the clarification of how you just clarified it. Can you clear the
Are you
circle,
done with
please?
this exhibit?
Yeah.
All right, we'll take it down. Thank you.
You made reference to a key being found. Did you yourself find that key?
No, I did not.
Were you at the scene where the key was found at the time it was found?
No, I was not.
So it'd be fair to say that you were told that a key was found.
Yes, I was told that a key was found.
So it'd be fair to say that you went off of what you were told. You actually didn't observe this with your own eyes.
What are you speaking of?
The key being found.
That's correct. I was told by two officers who I've worked with for a long time, and I trust what they tell me to be accurate.
You made reference to there being a couple, was the word you used, a couple ways to identify individuals. And you stated that you had spoken with the mothers of the alleged defendant's children. That be fair to say?
I believe I said I spoke with the mother of 3 of your children.
At that time, was the alleged defendant already in custody?
Yes, he was.
Wouldn't it have been easier to just use the fingerprints that were already obtained?
Like I said before, the fingerprints was one way. We also verified it talking to his family members that his identity.
Any reason why, or let me back up. Is it fair to say that there was more confirmation needed to identify the alleged defendant at that point, seeing as how the fingerprints were already obtained?
We were just being thorough. We were certain that it was Darrell Brooks that we had in custody based on his fingerprints and other information that we had. It was just a matter of being thorough and verifying the person that we had and the name that he goes by.
It'd be fair to say fingerprints are pretty accurate though, correct? Would that be fair to say?
I think that would be fair to say.
So it would also be fair to say that there wouldn't be any reason why the alleged defendant that was in custody would be someone else. Wouldn't that be fair to say?
Objection, that's compound and difficult to follow.
This is not compound. This is not
Sustained as to
difficult
the
to
form
follow.
of the question, sir. Please
That was
rephrase.
very clear.
Sustained as to the form of the question.
And where did the interviewing of the mothers of these children take place, if you recall?
I spoke to Jessica Macklin in Iowa at her residence. I spoke to Angel Fitzpatrick at her residence in Menominee Falls.
Whoa. Can we strike that? Why do the names have to be stated?
Overruled, he was answering the question. His answer may stand, your request to strike is denied, and the witness may continue answering.
I spoke to Angel Fitzpatrick in Menominee Falls at her residence, and I spoke to Erica Patterson a number of times at various locations about you.
You said one of the mothers of these children you spoke to in Iowa.
Correct.
Why would you go all the way to Iowa?
Because initially you listed her as a witness on your witness list for court. So we went there and we wanted to verify what information she might have that she would testify to.
Just for the record, I don't recall listing anyone as a witness, just for the record.
For the record, Mr. Brooks, you can't testify at this
don't know
moment.
that.
You'll have an opportunity should you choose.
I just wanted that clear for the record since
It
what was
can't be,
said.
it's struck from the record at this
I-
point
I-
because you're attempting to testify.
I'm
The
not
jury will
attempting to
disregard
testify. I
that.
just wanted the record to show
The
that I
jury
had no
will
knowledge of doing that. And if
The jury will disregard those statements made by the defendant
If
as
something's-
that he is not testifying, and it would be improper at this time for the court to receive them.
I don't think a
Go-
record should be
next
made of
question, sir.
something that I didn't do.
Next question, sir.
It's ridiculous. So you said you went to Iowa to try to find out what would be testified to. Why?
Objection, argumentative,
Grounds.
irrelevant, and calls for hearsay.
Grounds.
Sustained as to all basis. Next question.
Was that an attempt to prepare for what might have been said?
I'll allow that.
Okay.
Go ahead.
Yes.
Why would there be preparation involved in someone who might testify on an alleged defendant's behalf?
Objection, argumentative.
Grounds.
Overruled, I'll allow it.
We went there to speak with her, so if she came and testified, there wouldn't be any surprises. We also wanted to find out if there's any background information that she had about Mr. Brooks that would be helpful in our investigation.
So you made reference to not being any surprises. Would it be fair to say that there was a little worry there?
Objection, argumentative.
Grounds.
Sustained as to the form of the question.
What surprises were you referring to? What do you mean by surprises? No surprises.
Your Honor, I object to this entire line of questioning. This witness is not expected to testify. It's wholly irrelevant.
Well, he opened the door by putting the name on the record and saying where he went.
I will allow one more question on this. Go ahead, you may answer.
Could you re-ask the question, please?
What do you mean by making sure that there were no surprises?
We wanted to make sure that there wasn't any information that we weren't aware of that may come up later that would be helpful in the trial.
Do you recall making an attempt to interview the child
Objection, relevance.
who was 7 at the time?
Sustained as to, next question, please.
Reason for the sustain, Your Honor?
Not relevant.
Well, the question was asked, does he recall?
Sustained, next question, please.
Grounds for the sustain again?
Relevant.
How is it not relevant?
Keep going, sir.
Did you interview the child?
Same objection.
Grounds.
Sustained.
Grounds for the sustain?
Relevance.
Why would you ask to interview the child?
Your Honor, objection. This
Sustained.
entire line of questioning is inappropriate.
Sustained. Move on.
I would
Mr. Brooks.
object that trying to interview a 7-year-old child is,
Sir, move on, please. 90611. It's also not relevant. Assumes
very
facts not in
relevant.
evidence.
it was a tricky move. you made reference to, in regards to Exhibit 88 and 89, which were documents from an entirely different county. Do you work for Milwaukee County?
No, I do not.
So how did Milwaukee County, which is a different county, come into your investigation in Waukesha County?
You may answer. With the understanding there are some limited pretrial rulings that still are in play. Go ahead.
During the normal,
I'm sorry for interrupting. I started off by saying in regards to Exhibit 88 and 89. That's how I started the question, just for the record.
I know. I'm reminding the witness of the pretrial rulings.
Okay.
during the normal course of an investigation, we do background on a person to see if they have any open cases or any information that would be helpful. There is a computer system that displays what cases or charges are open for a person, and it is relevant because if you are charged in one county and you violate conditions of bail, you can also be charged in another county for those violations.
And in reference to having charges in one county and potentially being charged in another county, in reference to that, wouldn't you essentially have to violate the conditions in one county and strictly be charged in that county?
That is an inaccurate statement.
You being in law enforcement for a very long time, it would be fair to say that you're familiar with the term double jeopardy, right?
I've heard the term before.
And what is your understanding of what that term means?
Objection, irrelevant, beyond the
Grounds.
scope of the witness's knowledge, legal conclusion.
Sustained for all those reasons.
So when did you become the lead investigator in this matter?
It was about 8:30 p.m. on November 21st, 2021.
So same night.
Correct.
And whom were you made lead investigator by?
The command staff or Lieutenant Jerry Habanik.
Do you recall why you were tapped to be the lead investigator?
Because I was the most qualified person, had the most experience to take care of it. That's what I've been told.
Any other reasons besides that?
Also because I was at the parade route a little bit earlier and I had the most information out of anyone. It took a little while for the other staff to come in, so I already had a little bit of a head start with the information that I already had learned as being there at the beginning.
And that would be in the information that you said you had more knowledge of than anyone else at that time. Would that be in reference to having an interaction with the vehicle at some point?
I would say as the totality of the situation, I was there when the car first went through. I know what the radio traffic was for taking Mr. Brooks into custody. There's also some decisions that were made early on how to proceed with the case. I was also on scene downtown and took control of the crime scene initially. So a lot of those decisions were made even before our command staff started coming in to take over lead on the case.
You referenced you were there at the beginning when the vehicle first entered in the parade. What do you recall about when the vehicle first entered the parade?
I remember a horn beeping, red Ford Escape driving around, and then you driving into me and not stopping when I pounded on your hood and window.
Driving into you, what do you mean?
I meant that I was in front of your vehicle contacted me, pushed me off to the side, and continued driving without stopping.
Were you injured in this incident?
I was not injured, thankfully.
And you made reference to a horn beeping. What do you mean a horn beeping?
I mean,
The vehicle was beeping its horn?
Yes, the vehicle was beeping its horn.
What would be the only time a vehicle would beep their horn?
Objection, speculation.
Grounds.
Sustained. Calls for
Reason.
speculation.
Do you know why the vehicle was beeping their horn?
Same objection, Your Honor.
Do you know why you would beep
He
your
asked,
horn?
do you know why? So he can answer that question.
Could you repeat the question, please?
Do you know why the vehicle was beeping its horn?
I imagine that the driver was angry and wanted to get through the crowd.
And how did you come to that determination?
I've been driving a long time, and a lot of times people get angry, they're late, they beat their horn at you in a way that is because they're upset and they're trying to get past you.
Do you know that for sure?
You asked me my opinion.
Yes, I did ask your opinion. Now I'm asking you, do you know for sure if the driver of the vehicle you observed was in fact angry?
I assume that he was.
So it would be fair to say you don't know for sure.
I do not know for sure, but that is my opinion, is that he was angry.
And at that time, you had no knowledge who the driver was. Would that be fair to say?
Well, I had knowledge because I saw your face. I did not know your name
Did
at
you
that
know
time.
who the driver was? No, meaning had you had any prior interactions with them before this incident? That's what I mean by no. Have you had any conversations with him, talked to him?
Hold
saw
on.
him?
Compound question. Ask one.
I was just giving clarification of no,
You
what I
need
meant
to-
by
It's
no.
a compound question. Please rephrase.
Before you observed this vehicle, as you say, and this driver as you say, did you know them?
I have no memory of meeting Mr. Brooks before that afternoon.
So it'd be fair to say that you're assuming something that you don't know. Would that be fair to say?
Objection, compound, vague, and argumentative.
Sustained.
Grounds.
Sustained as to the form of the question.
How would you know how someone's feeling if you don't know who they are?
Your Honor, he opened the door to this. It's asked and answered. The witness has given his opinion. It's clear.
Grounds.
I object. Improper question.
Grounds.
I will allow the witness to answer why he came to that conclusion. Go ahead.
Like I said before, I've been driving a long time, and a lot of times when people are beeping their horns, it's because they're late, they're angry at something happened, and that's why I concluded that the person was probably angry.
So would it be fair to say that another reason why a vehicle would beep its horn would be to alert people to the presence?
Objection,
Grounds.
irrelevant, speculation.
Grounds.
I'll allow it. Based upon his training and experience, he may answer.
It's a possibility.
And did you hear this beeping before the vehicle approached you?
Yes, I did.
You made reference to, and I'm referring to the ring video obtained in exhibits 88, or I'm sorry, the ring video obtained in exhibits 13 and 14. You made reference to obtaining that the same night of the incident. Do you recall saying that?
Yes, I recall saying that.
And it would be fair to say that you yourself have been present for all testimony. Would that be fair to say?
That is not correct.
How so?
I was sick one day and I was not here.
Well, I'm referring to, let me clarify. Maybe I wasn't clear enough. Pertaining to all testimony since trial began, you've been present for all testimony. Would that be fair to say?
I believe I've seen most of it.
Do you recall testimony of and I'm referring to, again, so clear for the record, exhibits 13 and 14, ring footage that was obtained by the owner of 4014 North 19th Street, that you testified to obtaining the ring footage the same night. Were you aware that, well, let me back up just a little bit. How were you able to obtain that ring footage?
There was officers that went to Freighter Hospital where Dawn Woods, Mr. Brooks' mother, was working. They spoke to her, and she's the one that alerted to them that she had ring video at the house and offered to remotely download that video for them.
And were you there yourself?
I was not there myself.
When did you yourself speak to the owner of that home?
The last time that I spoke to Dawn Woods was on August 8th of this year. I may have spoken to her a few times before that. I don't recall the exact dates.
I'm referring to the first time that you spoke.
I don't recall
The very first time.
I don't recall the first date when that was.
And you did just make reference to an August 8th date. And what was the extent of that conversation?
Objection calls for hearsay.
Grounds?
Sustained. Hearsay.
The August 8th date that you referred to, was that in any way follow-up? Was that follow-up investigation?
Follow up to what?
Well, you stated that you had spoken previously before the August 8th date. So the question is, was the August 8th date follow-up to the investigation that you were already actively lead of?
I mean, everything is related to this investigation. The
So-
investigation continues every day. It will not end until this trial is over.
So what follow-up was needed at the time of the August 8th interview? I'm guessing that's what you would call it. I don't know, I'm not sure.
Objection still calls for hearsay, Your Honor.
Sustained.
Why did you need to talk to Miss Woods multiple times?
Because every time we spoke to her, we got different information, and at that time, we were following up with your niece and nephew of what their testimony would be in this case.
What testimony are you referring to? Because I don't recall any nieces or nephews testifying.
I don't think I'm allowed to say it.
I think this line of questioning is irrelevant, Your Honor.
I'll sustain the objection, and at an appropriate break, I can address it further if need be. Please move on to a new topic, sir.
You made reference to people who were injured at the parade inadvertently. You recall that?
Yes, I do.
To your knowledge, were any of those charged?
My testimony before is that those people's cases were not charged.
And were they seen as victims?
I'm going to object to the form of that question. I think it calls for a legal conclusion, Your Honor.
It does not. I asked to his knowledge.
I'll sustain the objection as to the form of the question. If you could please rephrase.
I'm gonna go a different route. Do you recall serving a warrant to the Waukesha County Jail on July 1st of 2022?
Yes, I do.
Do you recall what that was for?
Yes, I do.
And what was that for? Can you state for the record and for the jury?
It's for Mr. Brooks's jail cell.
And why did you serve a warrant for a jail cell?
Your Honor, I object pursuant to legal rulings previously issued in this case. I don't think this is relevant.
I'll sustain the objection. It's not relevant. I'll certainly take it up at a later point if need be.
What was the warrant pursuant to?
I sustain the objection. Next topic, please.
He did answer.
I sustain the state's objection. I'm directing him not to answer. We'll take it up separately. I'll have you continue with your cross-examine. I'll take it up later.
made reference to this vehicle driving into you, but stated you were not injured. Did you file a claim in this matter?
No, I did not.
Do you consider yourself an injured party in this matter?
No, I do not.
Do you yourself know if anyone filed a claim in this matter?
Can you be more specific?
Do you yourself know if anyone filed a claim in this matter?
Just in general?
Whatever your interpretation of that will be.
I would say yes.
And do you know what that claim was?
I would imagine that there was a lot of injuries from the people. A lot of people had very extensive medical bills. And I imagine that they would file a claim with their insurance company to have those bills paid.
So you had knowledge of what was filed to their particular insurance companies?
I have no knowledge, but my assumption is that they would have filed those bills.
So it would be fair to say you don't know for sure.
That was my testimony.
Is that the answer?
Yes.
As lead investigator for this matter, where are you, to your knowledge, aware of any GoFundMe type of things?
Objection relevant? I'm sorry.
Do you mean as it relates to?
As it relates to the incident.
Overruled, the witness may answer.
I have no direct knowledge, but I assume that there are some GoFundMe pages out there. It's typical in something like this.
And what do you mean by typical? You've seen this before? Is that what you mean by typical?
We have a very loving and caring community where a lot of times when bad things happen to people, people pull together and offer financial assistance to help people.
Is it fair to say that there's a lot of communities like that across Wisconsin?
Yes, I think there are.
And it would be fair to say that you've worked extremely close with the district attorney's office during the entirety of this matter. Would that be fair to say?
The district attorney's office has been involved in this investigation since the night of, so we have worked closely.
So would it be fair to say extremely close, seeing as how you've been present for the whole trial pretty much?
Can you define extremely for me?
I would like you to define it extremely.
I'll answer yes if that helps.
To your knowledge, do you know if it's typical for a lead investigator to sit right behind the prosecution table at a trial?
Yes, it's very typical. It happens in most larger cases, especially a case of this magnitude. There would be a court officer. So yes, that's a very typical thing that happens.
Have you ever done this before?
I've done this multiple times before.
And are you the only detective in the investigation that has that honor?
Objection vague.
Grounds.
Sustained as to the form of the question.
Are you the only detective directly involved in an investigation that sits with the prosecution?
Talking about this case or any case?
This particular
or-
case.
I'm sorry, you interrupted me. Could you repeat that, please?
I believe he said this case.
I'm referring to this case, yes.
Could you re-ask the question, please?
Are you the only detective actively involved in this investigation that sits with the prosecution in
Yeah.
reference to this case?
Yes, I'm the only person, the only detective that's sitting with the prosecution during this trial.
So would you explain who the other officer is in the blue suit over there?
Objection to the relevance, Your Honor.
Grounds.
Sustained.
I just want to know his role.
Sustained. Next
Reason
question,
for the
please.
sustain.
Not relevant.
He's been in the courtroom the whole trial. How is it not relevant?
Mr. Brooks, next question, please.
Nobody knows who he is. That should be known. Nobody said
It's
that on
not
my back
relevant
tape.
to
I
the
don't even
issues
have a
that
back
the
tape.
jury needs to determine. Next question, sir.
Is it asking? We're telling. I'm assuming that's asking. You know what the other one would entail.
Do you have a question, sir?
Yeah, I do. I would like to get to it. Thank you.
Please do so. Thank you.
I will. So seeing as how you sat with the prosecution for the entirety of this matter, it would be fair to assume that you know who the plaintiff is in this matter.
Yes, I do.
And who would the plaintiff be in this matter?
The state of Wisconsin.
Is that an entity or a living human being?
It's an entity.
How can an entity file a claim?
Objection.
Grounds.
Legal conclusion.
Grounds.
Sustained.
You are aware that only a living, breathing human being can actually file a claim. An entity cannot walk into anywhere and file a claim if it's not even a real person.
Objection.
You
Move
are
to
aware of
strike.
that, right?
Go ahead, Attorney Apper.
Move to strike the statements by Mr. Brooks. Also object to the question that was asked at the end as irrelevant, argumentative, and calling for a legal conclusion.
Objection is not calling for a legal conclusion in any way.
The court sustains the objection. The request to strike the statements made by Mr. Brooks are granted, or the request is granted. The jury will disregard the statement and the question asked for all of the reasons indicated by the stated, also as a misstatement of the law.
No, I definitely object to that, Your Honor.
Your objection is noted. I'm going to have the jury stand for a second. They've been sitting for quite some time, and then you can formulate your next question.
I'll take exception to that ruling. And would like a legal finding of fact.
Your objection is noted. It's overruled.
And that's a judicial determination.
All right, thank you. Be seated. Go ahead, Mr. Brooks. Please continue with your questioning.
Have you ever had any interactions with this entity, state of Wisconsin?
Mr. Brooks, under 90611, I'm not going to allow the witness to answer. It's vague.
There
Please.
was no objection.
Under 90611, I shall exercise reasonable control over the mode and order of interrogating witnesses. Please, next topic. These questions we addressed during the initial cross-examination of this
They're
witness.
gonna keep coming up.
And I determined at that time that they weren't relevant. So next topic,
They're gonna
please.
keep coming up.
Under 90611, sir, please move on to a new topic.
They're gonna keep coming up.
For the cross-examination, I will end.
Do you see the state of Wisconsin president in courtroom today?
Objection, argumentative,
Grounds.
irrelevant.
Sustained. Final warning, sir. Next topic or the cross-examination, I will
You
bring it to
don't
an
gotta
end.
you don't gotta keep doing that, Your Honor. You don't gotta keep doing that.
It's my responsibility, sir, over this trial.
I'm informed. And
Thank you.
And I
Next
respect
topic.
that. But it's relevant for the jury to know the truth. They deserve to know the truth.
Move to strike, Your Honor.
Granted, the jury will disregard
Objection.
those last statements. They're
Objection
not
to that.
relevant. Mr. Brooks is not testifying. They misstate the law.
I object to that. That's not lawful law. It's
Noted.
untruthful.
All right, under 90611, I am now stopping the cross-examination. Any redirect by the state?
Objection to that, and I would like a
Noted.
legal finding of fact.
Attorney Opper, any redirect?
Yes, just very briefly, Your Honor, I would like to display for the witness only Exhibit 178.
Objection.
I haven't seen the exhibit yet, so I'll take that under
I'm
advisement.
objecting still because the
You may show it to the witness.
there needs to be an answer to why the jury's not being told information that they deserve to know.
Go ahead, Attorney Opper.
Your Honor, for the record, this is a video. I'm going to play about the first 5 or 10 seconds for the witness to identify it before moving on, please.
And this seems objection because this seems like a whole new exhibit. This was never mentioned before. It was never.
I haven't seen it. I can't rule on it, sir, so let me
I mean,
see it, and I'll
when
take
did
your
it become an
objection under,
exhibit?
I'll
It
take the
was never an
objection under
exhibit before.
advisement. Go ahead.
I haven't seen this in any of the exhibits that I have. So how could it just be created now and be made an exhibit?
Go ahead,
I
Attorney
have
Opper.
all the exhibits.
Go ahead, Attorney Opper. I haven't seen it yet. There's nothing on my screen that I can see. I see it's now playing.
So now we just creating exhibits now. I have all the exhibits, and this was never in it. Oh man.
All right, you can stop. Sir, do you recognize what's contained in State's Exhibit 178?
Objection.
Overruled.
Relevancy.
Overruled.
Leading.
Go ahead and answer.
Yes, I do.
What is it?
Objection. Leading.
Overruled. The witness may answer.
You still don't. I'm still going to object. How is this?
Mr. Brooks, I ask that you honor
I have all
the ruling that
I
I've
have
been
all the
made.
exhibits, though, Your Honor. I have them
Mr.
all.
Brooks.
They were provided to me, and this was never in the exhibit. So how could it just be made an exhibit?
I'll take
just
this
out
up
of the blue?
outside the presence of the jury, but I'm going to allow it.
Can that be stated for the record? Can that be explained?
No, the jury will disregard the statements made by Mr. Brooks. They're not evidence, and the state may continue.
So this exhibit shouldn't be evidence then, because it
Mr.
didn't
Brooks, the
exist before
objection's
today.
noted. It's overruled. Go ahead.
There was a still photo shown before of Mr. Brooks
This is
standing in front of the Ford Escape. This is the video in which that still photo was taken from.
You could
Objection. How does he know that?
Overruled. The witness may answer. I'll give you the opportunity to question him about it when the state's done asking the questions. Go ahead.
Where'd you get this video from, sir?
Objection. Leading.
Overruled. The witness may answer.
From Mr. Brooks' social media account.
Okay. Your Honor, move to admit 178 and permission to publish.
Objection to the relevancy.
I'll
And
find that
still
it's
don't know how it
relevant.
was
I'll receive
obtained.
Exhibit 168. Permission to publish is granted. For the record.
It's
Could you please-
178, Your Honor.
No, could you please tell me the length of the video?
The length is 2 minutes, 33 seconds. We're going to play it in its entirety, but without volume, Your Honor.
All right, thank you.
And
I object to that, and I would like to make an offer of proof for my appeal.
We'll do that outside the presence of the jury, but I will allow the state to play it in its entirety without audio.
Your Honor, I have all the exhibits. They were provided.
Mr. Brooks, I'll take that up along with the other two issues I still need to
But
address.
how can you play something that's not, that I didn't even
Mr. Brooks,
have?
I'll take that up outside the presence of the jury.
This
Your
is
objections are
mind-boggling.
noted.
This is
It's
mind-boggling.
overruled.
Mind-boggling.
actually, Your Honor, I changed my mind. I would like to play the audio, please.
This is mind-boggling.
I want to have it played first without, and then I'll make a ruling and I'll take that up.
Okay, I understand.
Thank you.
So we will play the entire video, Your Honor, 2 minutes, 33 seconds.
I object to that. Why does the whole video need to be played? Is this setting the foundation?
It's relevant. You questioned the officer about it. You
I
questioned this
question him
detective
about,
about
I
his
question him
knowledge.
about the still frame from the video. The video wasn't even in the exhibits that I received. I actually didn't even receive them. They
Mr.
were
Brooks, please
obtained.
stop. The jury will disregard his statements. He's not testifying. The video's playing.
So play the sound. I want to hear it now.
I'll address that later.
We address why it was created out of the blue too.
Go ahead, attorney, after the video is finished playing.
Thank you. Sir, did you see during the playing of that video the image that was captured as a screenshot and presented to you in your direct testimony as states exhibit number 175?
Objection leading.
Overruled, foundational. The witness may answer.
Yes, I
A lot of
You
things
were
that could be
questioned
captured.
on cross-examination as to your ability to identify Mr. Brooks in exhibit 175, correct?
Objection. That question was asked initially by Attorney Hopper.
Overruled. The
Yeah.
witness may answer. Sorry.
Yes, I was.
As you just watched the entire video again now in court, as states exhibit 178, did you clearly see Mr. Brooks in that video, sir?
Objection leading.
Overruled. The witness may answer.
I believe there's no doubt that that's Mr. Brooks in the video and later standing next to the Ford Escape.
Thank you. I don't have any other questions, Your Honor.
As to this particular piece of evidence only, Mr. Brooks, you may ask questions of Detective Casey.
Objection. I don't consent to being called that name. And yeah,
Noted.
I
Do you
got
have any questions for the witness?
This when did this video? When was this made a exhibit? Because I don't have it.
Objection, that's not a question for the witness, Your Honor.
That
Sustained.
was a question. When was
Sustained,
this
as to the
video
form
made
of the
an exhibit?
question.
When was this video made an exhibit? That is a question.
I object to the question directed at the witness, Your Honor. It's beyond the scope of his knowledge.
Sustained.
Well, he said he saw it.
But that's not the question asked. So you can rephrase your question if you want to.
When did you see this exhibit? When did you see it?
With the understanding that you're asking when did he see the video, I will
When
allow
did
the
you see
question
this
to be
exhibit?
asked. With that understanding, you may answer Detective Casey.
Am I answering when I saw the video for the first time?
Yes.
Objection, Your Honor. Why is something always funny at that table?
I-
It would be the same thing. I'll take that as disrespect because they were allowed to say something and I said under my breath that was disrespect.
I
They
would
just
direct
did the
both
same
parties
thing.
to avoid commentary.
Okay, well, can
and
you do that,
gestures
please?
and faces.
Admonish them
Yes,
because
I
I'm
will.
always the one getting
Absolutely.
admonished.
Everyone.
I take that as disrespect too.
Sir, I'm good. Can I do my job? State's directed to avoid laughing, commentary. I didn't see it, so I can't further comment. I was looking at
All these
the
cameras
witness.
in here, don't nobody
However,
never see nothing.
I'm advising both parties to show
Come on, man,
decorum
this is not fair.
and restraint, to be
I'm with-
respectful of this jury's time and attention, and to let them do their job by focusing on the testimony and exhibits and evidence that's presented. Go ahead, Detective Casey, you can answer the question about when you have seen this video prior to today.
I saw the video within a few days of Mr. Brooks being arrested. I've reviewed it since then a few times. I reviewed it yesterday and again this morning, and now in court again.
You said you reviewed it yesterday and this morning. If you had seen this video numerous times before yesterday and today, why did you feel the need to view it yesterday and today?
Objection, argumentative.
Grounds.
Sustained as to the form of the question.
Why did you need to review it this morning?
Objection, argumentative.
Overruled, the witness may answer.
Because I wanted to be 100% sure of the content, and if there's any questions that were asked of it, I wanted to make sure that I would be able to answer them appropriately.
And why was this, to your knowledge, why was this video never brought up in your earlier testimony?
Objection, that's a
Grounds.
misstatement, Your Honor.
Sustained as
it
to
was
the
not
form
brought
of
up
the
in his
question
early
assumes
testimony.
facts not in evidence.
If you had seen it numerous times before today, why did you need to see it again to make sure if any questions were asked, or however you refer to it? What would be the need to view again this morning something that you had viewed numerous times before?
I will stay with my
Objection,
Hold on.
objection, compound, asked and answered, misstatement of the facts, argumentative.
Sustained.
Did you view the video this morning because you knew that the video would be made an exhibit this morning?
Objection, assumes facts not in evidence.
Sustained as to the form of the question.
This is mind-boggling. This is mind-boggling. Can you clarify again why you viewed the video this morning?
Objection, asked and answered.
Sustained.
So you're gonna sustain everything?
It was already answered, sir. Next question, please.
And I'm asking for clarification.
Next question, please.
I don't got no more questions, man.
All right, thank you.
This is mind-boggling.
Detective, you may step down. I'll excuse the jury.
What you people was trying to do is not fair. Hide things from the jury repeatedly. You don't tell them all the information
Mr.
they
Brooks,
need
I'm
to
going
know.
to take up all of your objections outside the presence of the jury. I'd ask that you honor my decision to do that and you show courtesy and decorum.
Because you asked.
Mr. Brooks, please.
Because you asked. That's the only reason, because you asked. I see what you people are trying to do. It's not right. It's not fair and it's not right.
You can have a seat. Well, once the jury's outside of the courtroom, I'll take up the objections previously in the evidence. All right. First of all, Attorney Hopper, if you can make a record as to this exhibit and whether it's been turned over previously.
It was previously included in the initial discovery that was sent initially to the public defender's office, and now we have a record that those 3 boxes were turned over to Mr. Brooks.
Objection, I don't consent to being called that name, and it was not in the video footage that I have obtained. That video was not part of it. Do you think I would sit here and be this irritated?
Mr. Brooks, I need to make a record, so just please sit down. There's no need for you to stand at the moment.
I feel like standing right now.
Please sit down.
I feel like standing.
All right, based upon the offer of proof provided by the state, and it was provided to prior counsel, that satisfies me as to that issue.
That's
I
inaccurate.
indicated
That's
I would.
inaccurate, Your Honor. Can we have the prior counsel testify to that then? Because
Not at this time, sir.
I have not obtained that. Right now, that was my first time seeing that as an exhibit.
Mr.
That's why I
Brooks, I
raised the
presume, and you can correct me if I'm wrong, but you're familiar with that video? Yes or no?
What does that have to do with what we're talking
Because
about?
I'm going to make a finding based upon what I viewed in that video, that there's absolutely no surprise to you. It appears to me, even without the video, that that's a music video, that you are in it, that the vehicle that has been the subject of this entire case, that red Ford Escape with the plate that's been testified to, is in that video. That video is relevant for a number of different reasons, the first of which it goes to identification of you, identification of the vehicle. You opened up the door through your cross-exam of Detective Casey about his ability to identify you in that video. And when I say identification of you, specifically as it relates to Detective Casey's opinion that that's you in the video, of course, it's ultimately up to the jury to determine that and what relevance, if any, the evidence have, but you opened up the door for the state to show that video because you directly attacked the credibility of Detective Casey through his knowledge of it and the identification by him of you in it. Because the still image was of your back.
Okay.
So that opened up the door, and it's proper. There's absolutely no surprise to you that that video exists, and that is my finding as it relates to that.
What do you mean by it's no surprise to me that it exists? That was not the issue. The issue was, how was it made an exhibit at the last moment? How does it be made an exhibit out of the blue? That was the issue. The issue
State can
didn't
make an
have
offer of
anything to
proof
do
on
with.
that because obviously they marked it as an exhibit.
Well,
They
with
had
all
it,
respect,
so go
Your
ahead,
Honor, you're
Attorney Hopper.
mischaracterizing what I said, and the record needs to be clear. The issue that I raised was, how does this, at the last minute, out of the blue, become an exhibit?
Attorney
That
Hopper,
was the
go ahead
issue.
and make your offer of proof on that.
Thank you, Judge. And another thing worth noting is the testimony of Detective Casey that this video was obtained from the defendant's own Facebook account as well. The court is well
Objection.
aware.
He said social
There's
media. He
nothing
didn't say
Hold
what it
on,
was.
sir, stop interrupting. We have to make a record of it. You've
Then make the record
interrupted multiple times. I've been abundantly patient
record
with
clear.
you. Again, another interruption. So you need to be quiet and let the state make a record. Stop gesturing at
asking
me.
me to be quiet?
Stop rolling your eyes at
Are
me.
you?
Stop
I'm
mumbling.
looking right at you. I'm not rolling my eyes.
No, you
I'm
have
looking.
throughout. I've seen it
I'm
and I've
looking.
made note
I'm
of
looking
it.
at you. Okay, so are you asking me to be quiet, or are you telling me to be quiet?
Go ahead, Attorney Hopper.
Thank you, Your Honor.
gonna take that
And
as
just
asking.
to indicate, Your Honor, this court has been abundantly patient with Mr. Brooks. He challenges the court's authority repeatedly. This court absolutely has the ability to tell him, sit down and be quiet. And you haven't done that. And I know why you haven't done that, Your Honor, and we appreciate that. He is not in control of this courtroom. You are. And he needs to respect that. This video was relevant based on his questioning of Detective Casey, as you just indicated, challenging his ability to identify the person who had their back turned to the camera in the still shot of State's Exhibit 175. Trials are fluid. When he opened the door to that We came up with the video, which Detective Casey testified repeatedly on direct examination and cross-examination as to how he knew that was Mr. Brooks, because he had seen the rest of the video. He would not accept that. He pushed it and pushed it and pushed it until we played the video. The lyrics of that video probably would have been prejudicial. Originally, I wasn't going to ask for volume. Then I did, because he pushed it again, and his voice and his mannerism of speech, I thought, would have assisted the jury in identifying Mr. Brooks as the person in the video with the red SUV. However, you smartly asked me to play it without the audio, and I did that, and then I never went back to that. This is all to the benefit of this defendant, who continues to suggest and impugn the integrity of this court and this prosecution without basis. He doesn't like it because the evidence is stacking up and stacking up, and whenever it does, his response is to accuse you, the court, or the prosecutors of being unethical and hiding things. There is nothing in law that prevents me from pulling something out of my briefcase right now and making it an exhibit if it's relevant. You decide what's relevant, what's admissible, not Mr. Brooks. There is no law, he can cite to no law, no authority whatsoever that says I can't make an exhibit essentially on the fly if it's called for, and that's exactly what just happened here. So I apologize for my tone with the court. I don't mean to direct this at the court. It is very frustrating. The court has demonstrated much more patience than I have with Mr. Brooks, because again, I do not appreciate his impugning the integrity of these proceedings, of Your Honor's efforts to run a fair trial, and of our efforts to run a fair trial. We have ethical obligations as well to be fair in this courtroom. We have respected that entirely. The reason I was laughing 30 seconds ago was because the exhibit was mislabeled. There was an extra Y and it said Exhibit E, EXHIBITY. And I turned around to the paralegal and pointed that out, and we laughed over it, the word exhibity. That was it. There has been no disrespect directed at Mr. Brooks directly in any fashion. So he can object all he wants, and he has made that clear. He will continue to object and obstruct the court and obstruct these proceedings every last chance he gets. But legally, everything has been above board and proper, and this exhibit is no exception. I apologize for my tone, Judge.
Thank you. I appreciate that additional record being made.
I object to that.
My previous ruling doesn't change in any way that the exhibit is relevant. I indicated I would take it up because, and I'm taking what the state's saying as withdrawing the request to play the lyrics.
That is correct.
All right. I have not heard them, but I'll certainly take the state at its word as an officer of the court that it would be prejudicial based upon the lyrics that are in that video, but my decision to admit the video without audio stands. I do want to take up two other issues. There was an objection to questions regarding cross-examination. So the objections were by the state. One had to do with there was questioning about possible testimony with his niece and nephew, and then the jail cell search issues. So Mr. Brooks, you asked the questions. The state had objected. Since you're the proponent of what would presumably come in through the testimony of Detective Casey, what is your offer of proof as to why I should allow Detective Casey to come back on the stand and testify about his interaction, I believe it was with your mom, and possible testimony of your niece and nephew?
It don't matter with Detective Casey. He's off the stand. He's not going back on the stand.
No, but I told you I would recall him. I wanted to take it up outside the presence of the jury.
How do I supposed to know?
So are you withdrawing that, sir?
How am I supposed to know? I think I deserve a chance to rebut what was just said. I think I deserve that much if it's a fair trial.
What information do you want to provide to me
Oh.
about that last exhibit?
About what last exhibit? I'm talking about the audacity of the prosecution to just put that on the record when it's stating it's untrue.
I don't know what you're talking about. What's untrue?
We just heard her talk for 5-10 minutes straight. Now don't nobody know what I'm talking about.
I don't
There
know
was a reference made
specifically
to
what you're talking
there's a
about,
reference
sir.
made to what I'm supposed to know about the evidence stacking up and this and that, as if that has any bearing on what I still think and what I'm still going to present. It doesn't.
Well, that's not what we're talking about at the moment. I made a ruling on an
She's
exhibit.
been laughing and making comments under her breath the whole time during the whole trial, and I never said nothing. I don't know what's being said, but I can tell that it's directed towards me. I'm not an idiot.
I
for her to sit there-
haven't made any of those observations,
I didn't
sir.
say
What
you.
I've observed.
I didn't say you, Your Honor.
No.
But
What I've
for
observed
her,
is
for
as.
her, listen, please.
Go ahead.
For her to sit there and try to play it off as if she's not referencing to me, she must think I'm an idiot.
Nobody
That is
said
very
that, sir.
disrespectful to me. I haven't said anything about that until today. She's done it numerous times.
What are you talking about? I don't
Her
know what you're
laughing under her breath. Her trying to cover up the microphone so they can laugh and hee and key. That they've been doing that the whole time. I didn't
need
say
specific
anything. I didn't say
instances, sir,
anything
because
about it.
I have not noticed that. What I notice are 3 attorneys who cover up the microphone so that they're not heard when they're conferring with each other about evidentiary issues or about testimony.
So why is it always laughing and giggling
I
involved
haven't
with
noticed
that?
that other than the one thing you pointed out
Well,
today.
we have
which then-
cameras. That's what the
Mr.
cameras are
Brooks,
for.
let's refocus our attention on what we're here for, and that's
Okay,
this
then
trial.
I take
and
that
do
as-
you have
I
anything you
take
want to
that
put on
as-
the record?
I'm putting it on the record
As
if I get a
no,
chance.
you need to let me finish. As it relates to the video and my decision to admit
She
it.
just admitted that she just now came with the exhibit. It was not that she just said she just made it an exhibit. It
That
was
doesn't
not
mean
an
it wasn't
exhibit
turned
before she
over
made
to
it
you.
one.
So do you have some legal basis, sir, for your position? Because I'm not
What do
aware
I
of
need
any.
legal basis for when she just admitted on the record that she just made this exhibit up
No,
right
she
now?
didn't. That is a complete mischaracterization. Sure, she did not.
That's what. So she wasn't
Create
implying
the
that by saying
exhibit.
that she could
She did
pull
not make it
anything
up.
out of her suitcase.
So that's a figure of
During,
speech.
okay, so what is
Right.
it implying to? What would that be implying to?
As attorney,
How would anyone-
all right,
how would
I'm
anyone in
moving
my
on
position-
because you're not
How
providing me
would-
with any
how would
legal
any-
basis.
I didn't even finish.
For me to,
You told me that I can make the record. I'm attempting
sir,
to make the
well,
record.
Sir, as it relates to the video and my decision to admit it, do you
I
have
just said
anything?
that you didn't even let me finish.
You're not letting me finish.
You didn't let me finish either, Your Honor.
Because you're not providing me.
But how do you-
rant,
how do you know I
you're
wouldn't get to
providing
that if I
commentary.
didn't finish?
You're not providing me with anything from a legal basis for which I would consider changing my mind. So the state's withdrawn their request to play the audio.
Then why play the video at all then?
I've already made a ruling on that. You're questioning the ruling. You're not asking me to reconsider it based on any legal basis.
There should be a legal reconsideration of it.
Then you need to provide me with the legal basis for that, sir.
So I'm supposed to just come off that with off the top of my head?
Yes.
That's ridiculous.
You're representing yourself. It's not ridiculous.
It is ridiculous. So I was supposed to already come in here this morning and say, oh, a video is going to be shown off the fly at the drop of a hat. Let me try to find some legal thing to combat. How am I
Mr.
supposed
Brooks,
to do
you
that?
opened, the bottom line is you opened the door to
It
the
doesn't.
playing
It
of that
doesn't.
video.
We're not talking about
And the
opening
video
no
was
doors.
previously provided to you during
We're
discovery.
not talking
There's
about opening no doors. We're
absolutely
talking
no-
about being fair.
There's
Because
absolutely
if I
no
would have did
prejudice
that,
to
Your
you
Honor,
in
with all
terms
due
of
respect,
surprise
with
by
all
the
due respect,
exhibit.
if I had
Right.
done that,
I am going to move on
if
from
I
this
had done
topic.
that, it would have been a
Brooks,
big
I'm
thing.
advising you
Are you
that
asking
you
me?
need. I'm advising you, sir.
Oh, okay.
I'm
I don't know what that
advising you
means.
to sit down
I
and
don't
be
know what that
quiet.
means.
And if you interrupt me again, you are on notice that you will forfeit your right to be present
So
in
you're
this
holding me in
trial.
contempt
Mr.
for the
Brooks,
entire trial? Did you say the entire trial?
I never said any such
You said
thing.
for the trial. So what do
Please?
you mean? I'm asking. What do you mean?
Mr. Brooks, you continue to
That is
come
not.
at me.
I don't consent to being called
You
that name.
continue to fight with me.
I'm
You
not
are
fighting
being
with you.
disrespectful.
I'm not fighting with you. I'm not.
I'm
But
going to give you
said I
one
would have
last
the chance to make the
opportunity to
record.
sit down and be quiet so I can make a finding
Are you
as it
asking
relates
me
to
to
other
do
things.
that? Are you asking me
I don't
to
need
do
to
that?
ask, I'm telling you. Thank you. There were two other issues that came up that I advised the parties I would take up outside the presence of the jury and give, if appropriate, Mr. Brooks the opportunity to ask further questions of Detective Casey. There was questioning by Mr. Brooks about possible testimony and why it had to do with it was in the context of him questioning Detective Casey about speaking with Dawn Woods, his mother, and about a time in August, and there was some reference to his niece and nephew. And I sustained the objection. I wanted to take it up outside the presence of the jury. That's the first issue. The second issue was the questioning of Detective Casey by Mr. Brooks related to the jail search. Do you want the opportunity to question Detective Casey about either one of these two topics, is my first question.
Okay, why was it an issue with me bringing it?
Mr. Brooks, I'm only going to ask you one more time, and if you don't
I'm saying,
answer it
if I don't
correctly,
understand,
then
if I don't understand what was the problem in the get-go with the question, how am I supposed to answer it now?
Mr. Brooks, listen to me, please. I'm going to ask this question one more time.
Man,
It calls for a yes or no.
I don't like your tone and the way you're talking to me. I don't.
Mr.
I don't
Brooks,
appreciate it.
Sit down. I don't care if you don't like my tone. You've been
I'm not
pushing
gonna
my
sit down.
buttons all day throughout this entire
Okay, you've been
trial, and
pushing
I
my
have
buttons
showed
too.
the utmost of respect
No,
for
you
you,
haven't.
and I don't
Absolutely
appreciate
not.
you impugning the integrity of this court.
If that's
I
what you want to
don't.
call it, that's fine, but it's
Stop
not accurate.
talking.
What you mean, stop talking?
I need to make a ruling. Okay,
Well,
I'm purposely
let's
not
talk-
putting
let's
you in
talk
the
to-
other courtroom
Let's talk to
now.
each other like adults then.
Mr.
Because
Brooks,
I've never told you to stop talking.
I'm going to ask this question one more time, and if he doesn't answer it, I'll take it as a no. Do you want the opportunity to question Detective Casey regarding either his questioning or meeting up with your mom and your niece and nephew about possible testimony, or the search of your jail cell? Yes or no?
What was the problem with me asking the
All
question
right,
about
he's
the
not
jail
answered
cell?
my question. We'll move on.
I'm
not
trying
taking
to
that
understand. If I
All right,
don't
we're gonna take a
understand,
break.
how do
We're
I know?
recess, 15 minutes
How do
from
I
now.
know
Thank you,
what I'm
everyone.
supposed to answer if I don't understand? And I don't agree to a stop.
the record in State versus Brooks appearances are as they were before.
I think the audience needs to be turned on.
Yeah, let's do that. All right, let me do that again. We are back on the record. State versus Brooks appearances are as they were before.
I don't consent to being called that name for the record.
Are there any issues related to exhibits or other things before I bring the jury back out for what I believe will be the state resting?
No, Your Honor, I do believe that I did check with your clerk. Everything that we have offered and admitted matches what the court has, so I believe we are good on that.
I had one question
Oh, sure.
about Exhibit 89, and I don't know if I missed in my notes.
Okay.
What do the parties' notes reflect on whether that was received?
I showed that it was offered and admitted before it's published, or it wasn't published to the jury. But if not, we would move Exhibit 89 into evidence.
And do you recall what Exhibit 89 is?
It's a
Otherwise-
certified bail form.
No, I'm asking,
Oh.
I'm asking Mr. Brooks.
Oh,
So,
sorry.
that was the second of the two bail bonds. Do you have a recollection of whether it was received?
I don't.
All right, then what
I
was?
know I objected to it.
I know you objected when it was, I think, displayed for the witness who then testified about it. I'll receive it and also advise the jury. Were there any other exhibits? I have one other issue on evidence and exhibits as well, but are there going to be any other exhibits that we need to tidy up the record in front of the jury with?
I don't believe so. I know at one point, someone caught that we moved, it was either Exhibit 175 or 178 into evidence, and the court admitted either 165 or 168 on the record. So I don't know.
So maybe just
I
had a
think you
misspeak.
Yeah.
You have any recollection of that, sir?
Recollection of what?
Related to what the state just put on the record. Do you know what, was that, what witness that was?
That was Detective Casey.
Look at that. $175 was the screenshot taken from the video. I know I have a note that it was received and published. And you believe I may have just referenced it by the wrong name?
I thought it was 178. I thought you referenced it by the wrong number. So it's either 175. 175 was referenced as 165, or 178 was referenced as 168.
What is 170? I know that 175 is what I just said.
Correct.
What was 178?
178 was the video.
Oh, that was the
video.
most recent one. Okay. What's the request then as it relates to when the jury comes back in?
Your Honor, I just, there's two different ways to do this. I can put on the record, I have the exhibit numbers, and I can just put on the record just to verify that these exhibits have all been offered and admitted into evidence, and the court's agreeing, because we've just agreed that those are, your records are the same as my records. Or we can clarify just if there was some confusion about exhibits 175 and 178 that were shown to the jury this morning. Those 175 and 178 were offered, and the court has admitted those into evidence. So however you want to.
All right, sir, do you have any position on how I address this in front of the jury?
Yeah, I'm objected to him being admitted at all.
Well, those objections were already addressed. I'm talking about how I addressed to make sure the jury knows they were received by the court.
However you gonna do it is how you gonna do it. I don't think what I gotta say much matters.
Well, what you say matters, sir, but
No,
the
it don't.
fact that I've already ruled on the
Definitely
admissibility is not something I'm going to revisit.
What I gotta say.
Hold on,
definitely
that door is, all right, sometimes that door upstairs malfunctions and, all right, I didn't hear the last part of what you said.
What I have to say about anything definitely doesn't matter.
I take huge objection with that, sir.
It's true.
And that may be your perception, but that is absolutely not true. This court takes your positions on evidence, legal arguments, admissibility, things of that nature. I take all of that quite seriously.
But somehow it's always overruled or discarded.
Sir, can I keep going because you've interrupted me once again? My perspective on all of this, sir, is when you disagree with a ruling, you interrupt, you try to debate the topic again and again, you make disparaging remarks either directly or under your breath that are audible. Sometimes you roll your eyes. I mean, just previous to the break, you and I were talking over each other. I couldn't really get a word in edgewise. You wanted to debate topics that I've already made decisions on. I wanted to get clarification on whether you wanted to pursue any questioning, for example, with Detective Casey. I gave you multiple opportunities to answer questions directly. You chose not to do that. You directly challenged me about my authority in this courtroom. You refused to sit down repeatedly. Did I raise my voice? I absolutely did. Was I frustrated? I absolutely was. I'm sitting down. My voice is calm. I think the break was good. I hope for all it was good for me. We had a very long morning. It was about 11:30 when we broke. It's now 11:54. I didn't remove you to the other courtroom despite my repeated warnings because frankly I knew I was going to take a break. I just wanted to get through some issues outside the presence of the jury, which is the proper procedure for how to address objections if the record can't be done in a way that when a more full record needs to be made is how I'll put it. And I indicated during the cross-examination of Detective Casey, I would take your objections under advisement. I would address them outside the presence of the jury. You chose not to answer my questions, and so I moved on. Now, with respect to, I want to also address exhibits and the normal course of exhibits coming in a trial. Because I think there's some misunderstanding and certainly confusion on your part, sir, about the exhibit list that I asked the state to file near the beginning. And that was, frankly, to assist the court and my clerk in keeping track. Most trials, the normal course of action is as long as an exhibit has been provided to a party previously, or in some circumstances, if not, it's rebuttal. We're not quite there yet. That as long as it's been turned over in discovery, oftentimes parties will simply have exhibits marked as they're presented in the course of a trial. There's not a legal requirement unless a judge orders it that would prohibit a party from marking a document that's been already exchanged and having it offered as an exhibit. There was nothing improper about what the state did with Exhibit 178. And I want to make that record very, very clear. As Attorney Opper stated, trials are fluid. things happen. Parties can open the door to what might be inadmissible evidence for a variety of reasons. For example, this court made a number of pretrial rulings related to other acts evidence. Even during your cross-examination today, you came awfully close. I had the witness turn to me and pause and say, I don't think I can answer that, in a clear recognition that that witness, Detective Casey, understood his obligation to honor the pretrial rulings. And we moved on from there. I bet that's happened a half a dozen times in this trial. And that's frankly to protect your rights, sir. The door could have been opened a long time ago to the other acts evidence with Erica Patterson. And I frankly kept it out, despite your questions. So, with that, I want to bring the jury back out. I will ask the state, I'll simply just ask the state, are there any anything additional the state's offering by way of testimony or exhibits? You can then address the exhibit issue. Then I'll ask the state if the state has any additional witnesses, and the state can officially rest. Given the time of day that it is, it's 11:58. I'm not going to have Mr. Brooks start with his opening statement. We'll do that when we come back after the lunch hour. I think, frankly, the time over the lunch hour will be good for everyone to regroup, hopefully get a little bit to eat, and come back fresh. And then we'll have his opening statement and the start of testimony. Before I bring the jury out, there's one other thing I want to do, though. I just need a moment to pull something up from on my computer.
So is that addressing subject matter jurisdiction that you're pulling up?
No.
When would that be proven for the record?
Sir, please don't interrupt me. I need to focus on what I'm doing.
I'm not interrupting you. I'm just asking a question.
All right. I'm not going to be addressing that.
So would it
don't
be proven
interrupt me right now. I'm trying to do something on my computer.
Would it be
I need to
proven on the
focus.
record?
I feel it's important at this time to at least give you the advisement pursuant to Special Material 28. It is regarding your decision on whether to testify. I'm not asking you to make that decision, but since we're on the verge of you starting your case and it may impact your opening statement, I wanted to go through the following. Sir, are you aware that you have a constitutional right to testify?
I've been informed.
Are you advised and informed that you also have a constitutional right not to testify?
I'm not advised, I'm informed.
Are you advised and informed that the decision whether to testify is for you to make?
I don't understand the question.
Are you advised and informed that the decision on whether you testify in this trial is for you and you alone to make?
I'm informed. Not advised.
Are you advised and informed, sir, that if you choose not to testify, the jury will be advised that they cannot use that against you? In other words, you have that right not to testify.
I'm informed.
When you make a determination about whether to testify in this trial, I will further be asking you about whether anyone has made any threats or promises to you to influence your decision. I may also briefly go over your educational background. Did you hear me say that?
No, I'll say it again.
At the appropriate time, when we go through this discussion more fully, I will also ask you whether anyone has made any promises to you to influence your decision on whether to testify. Did you hear me say that?
I'm informed.
And then I will also ask you if anyone's made any threats or coerced you in any way in your decision to testify or not.
What's the significance of that?
So that I can make appropriate findings about the voluntariness, intelligence, and your, whether it's knowing, voluntary, and intelligent, your decision to testify.
So whether I give consent.
That's not the legal determination that I make. It is simply something that is your choice. I will honor your right not to testify. Obviously, that's a constitutional right. I will honor your right to testify. That's also a constitutional right. And the jury will be advised one way or the other. There's a jury instruction on that. Did you hear me advise you of all of this?
I'm informed.
All right. Okay, let's bring the jury out then. We can kind of tidy up the record and then we'll break for lunch.
Judge, may I remove that exhibit, please?
I think they're right there, so let me just take it.
All right, it's heavy.
Jury already coming out.
I'll just stick it.
Okay, so go
All
ahead
right,
and sit
for
it
the
back
jury.
down. Thank you. Subject matter jurisdiction still hasn't been proven for the record, Your Honor. Should be proven at some point.
Remind me not to do that twice. Remind me not to do that twice. Okay. That hurt. Oh, that hurt. Thank you, everyone. Please be seated. All right, then I'll turn to the state. Any additional evidence at this time?
The state has no additional evidence, Your Honor. May we make a record as to the exhibits?
Go ahead, please.
Your Honor, we believe that the court has admitted all exhibits that have been offered, with the exception of one prior ruling on Exhibit 6. I don't know if you want me to list them all by number, or there are, it's 1 through 78, 1 through 178, but there are some numbers missing because we chose not to offer those exhibits.
Anything specific as it relates to the most recent testimony?
The most recent testimony, with Detective Casey, we moved 177 and 178 and 175, 150, 151, 88, and 89. I believe those were admitted by the court.
That's my recollection as well, but for the jury, exhibits 150, let me start over. Exhibits 88, 89, 150, 151, 177, and 178. If I didn't receive them during the testimony, I'm receiving them now.
And 175, which was the still photo.
Thank you. Sorry, I had to scribble on my pad. And 175.
And 13 and 14. Those are the outliers. I apologize.
I believe those were received as well, but if I didn't
Objection, I
state
think
it,
they was already received.
I appreciate that. I just want to be thorough for the record. 13 and 14 were received as well. State have any additional witnesses to call at this time?
No, Your Honor, at this time the state rests.
All right, thank you. All right, then at this time we are going to break for the lunch hour. I am going to have everyone come back at 1:30. It's a little bit longer, at least that's what I want to do for the lunch hour today. So all rise for the jury. Thank you, be seated. Mr. Brooks, anything from you at this time, given the state is now rested?
What you mean?
I'm asking you the question. Do you have any requests at this time now that the state has rested?
What request pertaining to what exactly?
I'll ask the question one more time. Do you have any requests to make at this time now that the state has rested?
I don't understand what you mean by that. That's why I'm trying to get clarification.
I'm not going to give you legal advice. I'm simply asking the question. Do you have any requests to make at this time now that the state has rested?
I don't know what I'm supposed to say to that. I don't understand what would that be pertaining to.
I can't give you legal advice, sir. I'm just asking the question to make a record. I'll ask you one more time. Do you have any requests to make now that the state has rested?
I don't understand.
All right, the other thing I want to do when the jury comes back out is you will recall I read instruction 101 at the very end of the preliminary jury instructions that just has to do with opening statements. I will read that with the caveat. It will just say that the defendant will now make his opening statement. The purpose of an opening statement is to give the parties an opportunity to tell you what they expect the evidence will show you so that you will better understand the evidence as it is introduced during the trial. I must caution you, however, that the opening statement is not evidence. So I'll read that. I think it's appropriate given that Mr. Brooks deferred his opening statement until the start of his case. With that, we will take our lunch break. It's 12:09. If you could be back here at 1:25 and be ready to go at 1:30 with your opening statement.
I got a question.
Go ahead.
Do I get to present exhibits and stuff like that too and admit them into evidence?
At what point are we talking about? Do you want to use exhibits that have been received during your opening? Is that what you're asking me?
No, I'm saying if I got my own stuff that I want to offer into evidence, which is a question I asked previously.
Do you believe the state has all of those documents that they might be able to assist with? Or are they new documents?
I don't know what you mean by new documents.
Are they documents from the discovery that you have?
They documents of my filings and stuff like that. I'm sure they have copies of everything that I filed.
I guess without knowing specifically what you're referring to, sir, I did give you the admonition previously that you are prohibited from discussing subject matter jurisdiction during your opening statement. It's not relevant.
I'm not referring to the opening statement. I'm referring to things that I want to offer
Give me
for
an
evidence.
example, please.
I just did. I said I have filings that I want to offer into evidence.
That's too general, sir. I need a specific example so I can answer the question. What are you referring to?
My filings. Everything
Which
that I filed.
filings, sir?
Every one of them.
Well, they have to be relevant, number one, to the proceedings. Okay, number two, I don't know specifically what you're referring to. You can't offer testimony of yours through an exhibit. That would be hearsay. So you'll have to testify if it's your statement that you're referring to.
I'm not referring to I didn't say anything about testimony. I said
I'm
filings.
being general based on what I've seen thus far. So, are you talking about during your opening statement or during the course of the questioning of the witnesses that you're calling?
Your Honor, with all respect, I just clearly said filings that I filed.
Mr. Brooks, if I understood, I'd answer. I don't understand what you're asking me. You need to be specific.
I've filed a number of documents. I think that's on the record that I filed.
Without knowing what you're referring to, then my answer is no. But again, well, I guess I'll have to wait and see as to when you seek to admit them, whether there's any objection or not, and whether they comply with all of the rules of evidence and the rules of procedure. That's the best I can tell you at this point.
I don't understand what you mean by that. They will only be relevant to obviously the matter. They wouldn't be relevant to anything else.
I can't answer that anymore. We're going to take our lunch break. It's 12:12. We'll see everyone back here at 1:25. We are in recess.
So I'm not allowed to offer anything in the evidence?
For the record, I never said that. We are in recess.
So I'm trying to understand.
session. State versus Brooks appearances are as they have been. And Mr. Brooks, I presume you're ready for your opening statement?
Just 1 second. And for the record, I don't consent to that name, Your Honor.
Noted for the record. I intend to have the jury brought out. I presume you're ready to go?
Having a slight issue finding certain.
Can you sit up, because I'm not hearing you very well, so that the microphone picks you up, please?
I'm having a slight issue locating some of the files that I need. That's what I was trying to say.
All right, we'll take a moment. You can look. Tell me when you locate them.
Okay. Your Honor, I have a question.
Go ahead.
The files that I'm attempting to locate are pertains directly to the witnesses that I will be calling. I'm not sure what witnesses are here today.
Well, let's do this. I'd like you to at least do your opening statement, bring the jury and do that. We'll give you an opportunity to look again. I can have the state write down who's here. I believe it's based on what you told them. And then if there's still something you need at that point, but I'd like to at least bring the jury out and start with your opening statement, okay?
Well, just so I'm clear, I didn't give a specific order in who I will be calling by specific order. I gave a generalization of
Sure, I'll
who
have the
would be-
state, sorry.
who would be called on what day.
Why don't I have the state write down who's here presently, and then you can make that determination, but at least let's go with the opening statement, okay?
That's what I was trying to get at. It would help to know who's actually here today.
Before you make your opening statement?
Well, so I know if they're not here, then essentially I can't call them.
Let's address that after. I'll have the state write down who they know to be here now or who's coming this afternoon, because there might have been people here this morning. I believe they're still here, but I'll let them write that down for you so you can better prepare. But at this point, I would like to bring the jury out for your opening statement. I presume you're going to give one.
I am.
Okay. Then
Yeah.
I'll have the jury brought out, okay?
Subject matter jurisdiction?
My prior written decision stands. I will not be addressing that further. Your objection is noted, and I will be continuing with the trial.
Is it verified proof for the record?
Sir, I don't believe I need to do that, or that the state needs to do that as well. I believe your statement about that is a misstatement of the law, and I do not intend to pursue that further.
Can you show me lawful law that says that?
I gave you a written decision. I have done that.
Can you show me lawful law that verifies that?
Sir,
For the record.
I gave you a written decision. You
That I accepted for value in return for value.
and that's
because
how I'm going to answer that. So
it was
let's
not verified proof. We still aren't.
Sir, there is no requirement in the law that the state or the court establish that. So
Actually,
your
there
objection
is.
is noted.
All right.
Actually, there is, Your Honor. Subject matter jurisdiction has
Sir,
to
please.
be proven for the record. Has
It
to
does
be
not.
proven. Has to be proven. You know that just as well as
Mr. Brooks,
you know that.
please do not make statements that mischaracterize the law
You know it has to be proven
or that
for the
impugn the
record.
integrity of this court.
You know it has to be proven
and the
on the
proceedings
record.
here.
You know
The
it
jury
has
is
to be proven.
advised to disregard the statements that Mr. Brooks is making regarding subject matter jurisdiction. They are not evidence, and you are to disregard them.
You're not presented as evidence. Just has yet to be proven for the record.
The jury will disregard the incorrect statements of the law that Mr. Brooks is stating.
Where's lawful law that is incorrect?
Mr. Brooks, please. I am going to read one instruction. Thank you, everyone. Please be seated. The defendant will now make an opening statement. The purpose of an opening statement is to give the defendant an opportunity to tell you what he expects the evidence will show so that you will better understand the evidence as it is introduced during the trial. I must caution you, however, that the opening statements are not evidence. With that, go ahead, sir.
Obviously, I don't have any rehearsed or well prepared speech, so I'm just going to speak from the heart. I would just like to first say that I want to bring to remembrance something I think everyone in this room has been taught pretty much as far back as we can remember, is that there's always two sides to every story. And for so long now, roughly a year, there's only truly been one side told of this story. And I've sat back and watched from countless narratives that's been put out there, the way this incident has been portrayed at times, and finally everyone getting a chance to get the full story. You won't hear me try to argue facts. The fact is that this incident was tragic, very tragic. That's not lost on me. Facts are that there's still a lot of people healing, a lot of families healing on both sides. And when I'm confident that the evidence will show, sorry, I'm getting a little emotional. When I'm confident that the evidence will show is that this incident was not planned. This incident was not intentional. And this incident was never even thought about. It's easy to I'm sorry. Just need a second. think it's easy to look at the magnitude of something like this and form opinions. I think it's easy to disregard a lot of factors. And I think in reference to what I stated earlier, it's easy to forget the other side of the coin. There's been a lot of suffering involved in this incident. A lot. Obviously, with the families, with the community, and even the alleged defendant's family as well. There's been a lot of suffering. A lot of misunderstanding. And I just want you to keep in mind everything that will be presented in its totality. To keep in mind. The power that you have. I believe that should escape your knowledge. This has been a long process for everybody. And what I believe is when it's time for you to make your decision, all of you, I believe that, and I pray that it's the right decision. That all the factors are weighed. There's been a lot of words thrown out there about the alleged. A lot of speculation, a lot of ridicule. Words like demon. Words like monster. I know a lot of the time I've been before you, you see me with this mask on. Yeah, I've had my reasons for that. But I feel now is the time to, it's important that you see me for who I am. No mask for who I am. I think this is the moment for that. I pray that your eyes and ears remain as open as possible. And understand that you alone decide this case, this matter. The power is in your hands. All of you. To determine for yourselves what truth is. Thank you.
Thank you, sir. And do we have their writing materials available? All right, thank you. Mr. Brooks, you ready to call your first, would be your second witness, actually. Do you need a minute? I'm going to take a short break. I'll rise for the jury, please. We'll be with you shortly. The materials that you were looking for, let us know if there's something you need in that regard. And Attorney Opper, if you could perhaps just confer with him over which witnesses are here. I'll step off the bench while you do that, and if someone can just let me know, I'll come back out in like between 5 and 10 minutes unless I'm told to come back out sooner.
Yes, Your Honor.
Thank you. All right, thank you. Please be seated. Mr. Brooks, have you found what you were looking for?
I'm just gonna go with, I'm just gonna work off the list of the people who's here,
Okay.
if that's fine.
All right. You know who you're going to call first? We'll have that person ready.
Yeah.
Okay. You want to let us know so that the state can assist with that? Otherwise, you can just call when we are in front of the jury. So have the jury brought out, please.
Well, some of them are downstairs and some of them are out here, so it's fine. It just will take a few minutes if they're over in the main courthouse.
Okay. Why don't you tell the state, the first witness, to make sure they're right outside the courtroom, sir?
Most likely Bertram.
Okay.
Most likely. Most likely.
Do you want to give us 2 names and we'll have 2 people out there? I just want to make it go smoothly, sir. That's all.
Since I'm working off this list, I wasn't expecting that to be first.
Who do you want to call first? And we'll see if they're here.
Well, sorry.
That's okay.
Apparently, this list is who's here, I'm guessing.
That's my understanding as well.
Am I calling?
Not yet.
Okay, just checking.
Can't find out.
Is there someone you expected to be on the list that is not?
Kinda.
Do you want to make a record of that? Do you want me to address it in any way?
No, not right now.
All right, well, then I'm going to instruct the jury to come out, and then you can call your first witness. You can have this back again. There we go.
All rise.
Thank you, everyone. Please be seated. All right, you may call your first witness. Actually, your second witness.
The defense would like to call the plaintiff, state of Wisconsin, to the stand.
Your Honor, I object.
The objection is noted. It is sustained. Call your next witness, please.
Reason for the sustain?
Not relevant. And you haven't named a person to go along with it.
The subpoena was accepted, Your Honor.
I'll take the issue up outside the presence of the jury if necessary. Call your next witness, please.
Well, I would like to make an oral tennis motion to dismiss for failure to appear by the plaintiff and for failure to state a claim from which relief can be granted.
I will take that up outside the presence of the jury. Next witness, please.
So is the state not present?
Mr. Brooks, I'm not going to address that any further. while the jury's present. I'll take that up outside their presence. Call your next witness, please.
The defense calls Nicholas Kirby.
All right. Nicholas Kirby. Is that a witness who's in the hallway, do we know?
I don't believe in the hallway, but we will have him brought over, Your Honor.
All right, thank you. It'll be just a moment or two while we wait for that witness to come into the courtroom.
Sorry.
Sir, would you please make your way to the witness stand? It is up one riser to my right. When you get there, please remain standing. Raise your right hand, and my clerk, Teresa, who's across from you, will swear you in.
Do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Thank you, sir. Please have a seat. The first thing I will ask you to do is to state your first and last names for the record, and then to spell each. Go ahead.
First name Nicholas, last name Kirby, Nicholas Kirby.
Great, thank you. Go ahead, sir, your witness.
Good afternoon, Mr. Kirby. How are you today?
I'm here.
What do you do for a living?
Mostly temp work.
Do you recall the events of November 21st of 2021?
All too well.
And what were you doing that day?
What time of the day?
Around 3 o'clock-ish.
3 o'clock-ish. Around 3 o'clock-ish, I was walking with Corey around Waukesha. Earlier, well, yeah.
And you made reference to walking with Corey. Who is Corey?
Corey is a friend of Miss Patterson's.
And would it be fair to say that it's also a friend of yours?
Mutual friend, yes.
In reference to Corey?
Yes.
Oh. And what were you doing?
Walking around Waukesha, she was waiting for Miss Patterson to get done meeting with Mr. Brooks. You?
At 3 o'clock?
Around 3 o'clock-ish. Around that time, I had advised her not to go meet with Mr. Brooks.
You made reference to Mr. Brooks. Who's that?
That would be you.
And why would you say it would be you? That's you.
Because that's your name.
And you were privy to that information at the time?
I was privy to the information about you about a week prior to this incident.
About a week prior. And during your walking around, what were you doing with Corey?
Walking, like literally walking. We went from one store to walking around downtown after Erica told us she was going to be going to meet with Mr. Brooks. That would be you. I had advised her not to do it because it was a bad idea, and I was in fear for her safety.
You made reference to going from one store to another. What stores are you referencing?
Dollar General and Speedway.
Did you go anywhere else?
No.
Did you ever go to a park?
No.
You made reference to knowing about a Brooks a week prior to these events, you said?
I didn't know everything about him. Miss Patterson had showed me his rap sheet, if you will, and a picture of him, and that was about it. I had heard prior
I'm going to stop the witness unless you want him to go there, not to discuss what may or may not be conduct of Mr. Brooks prior to November 21 of 2021.
Okay.
With that understanding, go ahead and ask the next question.
You made reference to a picture you were shown?
Just a photograph with a rap sheet behind it.
And at some point, did you and your mutual friend Corey meet up with Miss Patterson?
Yes.
Do you recall where that was?
Corey and I were in the Dollar General area of Waukesha, which is between East and Broadway Street. We were walking away from Dollar General, towards where Erica had said that she was being assaulted and attacked.
And do you recall where that area was?
Yes.
Where was that area?
On White Rock Avenue, right across from White Rock Elementary, in front of the red apartments across from that area.
Red apartments.
Yes.
Do you know what those apartments are called?
I do not know the name. I'm guessing they're called White Rock Apartments.
And do you know if there's a park in that immediate vicinity?
There is a park there named Frame Park, yes.
Did you ever go to Frame Park?
No. We were in that area near the park where the elementary school is and the apartments are.
About what time did you and your mutual friend Corey meet up with Miss Patterson?
Miss Patterson called me and said that she was...
About what time was the question? About what
And I'm
time?
getting to that.
I'll direct the witness answer his question specifically. What time?
Honestly, around what time the parade started. I would have to say like dusk. I honestly don't wear a watch, so sorry, I don't remember the time. But if I had to put it at a time, I'd probably say about 4:35-ish.
Let's back up a little bit. Around what time did you and your mutual friend Corey first hook up that day?
I had worked that whole day, so we didn't meet up until I was done working, which was probably about 2:30, 3 o'clock.
And at some point, you received a phone call from Miss Patterson?
Yes.
You yourself?
Yes.
And then at that point, what did you do?
When she told me that she was in trouble and she needed help, I went to her aid, which means I took off from where I was near Dollar General and ran to where she told me to go.
And when you got there, what did you see?
When I got there, well, halfway towards White Rock Elementary, I stopped a police officer at a barricade and I let him know that a woman was being assaulted in a vehicle.
And do you recall giving a description of who may have been assaulting your friend?
No,
Why not?
because at that point in time, the description didn't matter. I had the identity of the vehicle. So I told them you need to be looking for a red SUV with a woman screaming out of it.
And how did you come into the knowledge of the description of the vehicle?
Because I saw the vehicle.
At what point did you see the vehicle?
When Corey and I were walking up White Rock Avenue on the apartment building side of White Rock, which would have been my right if you were walking towards the train tracks that cross White Rock. On my left was White Rock Elementary. I walked past the red vehicle, didn't realize that she was in that vehicle. Then Corey and I crossed the street to White Rock Elementary and started walking down the sidewalk, and I heard her scream, Miss Patterson scream. I don't remember exactly what she said, but she screamed and I knew it was her, so I walked back across the street and escorted her across the street over to White Rock Elementary.
I don't think that's what
I'm just giving you full description.
Let's back up a little bit because that doesn't make sense. You stated that you had a description of the vehicle. Would that be fair to say?
Yes.
The question was, how did you learn of the description of the vehicle at that point?
Miss Patterson told me over the phone that she was in a red SUV. There aren't many red SUVs with young women screaming for help in Waukesha. So I'm assuming, because you made reference to stopping law enforcement before arriving to the scene. Would that be fair to say? Yes.
So I'm assuming somewhere in the time of you stopping the law enforcement officer to report what you were being told, and then actually walking past the vehicle as you said you did, and then hearing this and all this, did you give a full report to law enforcement?
At the time when someone was in help and needed help immediately, absolutely not. I said there's a woman being attacked in a red SUV, you need to call for backup. Now.
And then you just ran.
And then I ran towards the person that needed help.
Did you at any time give a more detailed report that evening?
No, not that evening.
Did you speak with any more law enforcement that evening?
Yes.
Do you recall whom that was?
I do not recall the officer's name that showed up in the SUV coming down White Rock, in the police squad SUV. I don't even know the name of the officers that turned into Frame Park and went to the boat launch instead of where Miss Patterson, myself, and Corey were. But yes, I did speak to an officer.
How did you come into the knowledge of where officers turned and went?
Because me, Erica, and Corey were arguing with Mr. Brooks on the side of the road of White Rock, right in front of White Rock Elementary. And the officer that I had stopped at the barricade when we were coming to Miss Patterson's aid had radioed for backup, and obviously given them description of the vehicle that I had described to them, the red SUV. That backup came, but they went to Frame Park. They did not go to where we were on White Rock.
Any idea why they went to Frame Park if you specifically told them a description of a vehicle and where it was located?
I did not tell them where the vehicle was located because at first incident, Mr. Brooks had taken off in his SUV.
In the police report, and is it fair to say that the officer that took your report was writing down what you told them?
Do you mean the officer that I alerted about the trouble in the SUV?
Well, let me back up. On the next day, the 22nd of November of 2021, did you speak with a detective at that time?
Yes, I did.
And during that interview, were they writing down what you were saying?
I believe so, yes, but I believe it may also have been recorded on tape. I'm not sure.
And do you yourself recall stating to the detective that your friend Miss Patterson was being assaulted somewhere near the area of White Rock School?
Objection, lady.
Overruled. He may answer. I'll just caution Mr. Brooks about leading questions since it's his witness, but this particular question you can answer.
Yes, I mentioned that I had received a phone call from Miss Patterson and that she was being assaulted while in a vehicle.
At any time did you identify White Rock School?
I identified the street, which is named White Rock, the apartment buildings, and the school as well as Frame Park.
So you did identify Frame Park?
I identified the entire geographical area.
And at some point you said you heard your friend Miss Patterson screaming?
Yes.
And do you recall what she was screaming?
Objection, hearsay.
I said, do he recall?
As for the question, he's asking, did he hear? So you may answer. It's a yes or no.
I do not. Yes, she screamed. Do I remember what she was trying to say? No, I'm guessing it would be help. I'm in trouble. I would assume that that's what a person would scream when they're in trouble, is for help.
Do we still have the exhibit with the footage from the White Rock School available?
The security footage?
The security footage, I'm sorry.
We do. Would the state be willing to pull that up?
which exhibit he would like us to publish.
There's 3 and 4. Door 1 and door 2 is what I have.
I'm sorry, you said do.
Exhibits 3 and 4 have been received. One is of the White Rock door 1, the other is White Rock door 2. I believe those are the videos you're referring to.
Let's try door 2.
Okay, that's exhibit 4. Let's just put it up for the witness initially, make sure it's the one Mr. Brooks wants. I appreciate the state with their assistance. Can you see that on your monitor, Mr. Brooks? Is this the one you're looking at?
Yeah, I can see it.
I believe there's 2 clips from this, but go ahead.
Can you? This one is roughly 7 minutes, so I would need a little bit of it played, if possible.
It's been received, so go ahead. It'll be published, so everyone can see.
Well, before it's published, can you show it to the witness?
That's fine. We'll just play for the witness then.
I'm sorry, I should have said that before.
It's playing, so we'll let it go. Let us know if there's a point where you want it stopped.
Okay.
I'm not sure if this is the video you're looking for, though.
It might be. Think it might be door 1.
No.
What was exhibit 3?
No, maybe not. Let's watch. I could be wrong.
I was kind of thinking that too.
Take a look. Of course, none of our statements right now are any kind of evidence. We're just
Okay.
trying to get to the right spot.
Can you?
Pause right now at 105.
105. Can you back it up a few seconds? Not 2 or 3, but maybe 5 seconds, 6 seconds, maybe.
It's at 59 seconds. The witness. It is on the witness stand, by the way, just so you're aware.
Okay.
He's watching it.
Can you play from here? I don't think it's playing.
It's playing.
Oh, okay. Pause right there. From what you can see in this video, do you see anyone get in or out of the vehicle that you see on your screen?
Miss Patterson has just exited the vehicle.
Just for the record, the video was played. It's exhibit 4 from 56 seconds to 1:21. Go ahead.
I didn't hear the answer. I'm
Miss
sorry.
Patterson was the one that exited the red SUV.
You saw someone exit.
Yes.
Can you rewind it back?
To what? Again?
You want it back to 56 seconds?
No, to 105, where it was paused the first time.
Okay. Thank you for attempting to do that, Ms. Gussie. It is paused at 1:05. Do you want to play from here?
Yes, I'm sorry. Pause.
Paused again at 1:21.
Oh, okay.
Did you see anyone from, in the video that you're being shown now, from about the 1 minute and 5 second mark to where it's paused right now at 1 minute and 21 seconds? Did you observe anyone get in or out of the vehicle?
I'm going to take back what I said earlier. Apparently, according to this video, she did not exit your vehicle. She was behind the White Rock sign. That's why I did not see her.
Did you see anyone get into the vehicle?
Later on, within the incident, yes.
On the video there, you are able to view right now from the 1 minute and 5 second mark to the 1 minute and 21 second mark. Did you observe anyone get into the vehicle?
No.
Can you publish for the jury?
You want to replay it again?
Yes.
Go ahead. We'll start at the close to the minute mark as possible.
Again, is that where the defendant would like it started? Is
What?
this-
Around the 105, around that
From
area.
105, exhibit 4.
I know we have to wait for the jury, right?
Right,
Okay.
and then you want it to the minute 21 mark again?
Yes,
All right,
if
okay.
I may.
Go ahead.
And at that time, were you already en route to where you believe your friend was being assaulted at?
Objection calls for speculation. This defendant has not even put this witness at this location at this time. He's just having him testify about what he's seeing in video.
I understand the objection. It's sustained. Please establish some foundation for this witness being present at that location. For
Were you-
more information about the incident.
Were you present at this time?
We were on White Rock Avenue, but we were not in the general location of the school as of yet. As of that point in time.
So to your recollection, you didn't see anything that you're seeing right now or on this video, you did not see the day of the incident?
No, I definitely saw Miss Patterson in a red SUV that day.
Did you see?
At this specific time, no. Because I was down the road on White Rock talking to an officer who was manning the intersection of Hartwell and White Rock. And reporting at that time.
Can we play a little bit more, if I may?
Objection as to relevance. If he wants to direct the video to a certain time and he would like to ask this witness about that particular time, if the witness saw that, that's fine. But he can't go through each video and say, and ask general questions.
There's only been one video that's been shown.
I'm going to give Mr. Brooks some leeway on this. The video is to be played from this moment, and then Mr. Brooks tell us when you want it to stop.
Okay, what I'm attempting to do for the record, Your Honor, is...
Just play the video and you can ask your question.
All right.
Go ahead.
Can you pause it right there?
Video's paused at 1:38.
By what you are viewing in this video right now, had you and your mutual friend Corey linked up with Miss Patterson at that point?
At this point in time in the video, given from what I've just seen, that was when Erica was on the phone trying to get a hold of me. We were already on White Rock at that point in time. We were not near the school at that point in time, though.
So that was when you would, to your recollection, that's when you would say the phone call to you was made?
One of the phone calls, yes, she made multiple phone calls to me, I think probably about 6. I had been having issues with my phone that day, so it had been turned on and off multiple times. The final time that it was turned on was when I picked up her phone call, and she said, "I need help. I'm in trouble. Come help me. I'm being assaulted. That's when I left.
You just made reference to that point in the vehicle being, I'm sorry. I'm so drained. That point in the video was when you made reference to that point in the video being when you received the phone call.
Yes. A phone call out of multiple from her.
That's fair, a phone call. Would it be fair to say, though, that, and this is in reference to you saying that you were having issues with your phone that day, would it be fair to say that you're not sure how many phone calls you had received that day or who they were from?
I only received 51 phone calls on my phone that day that I actually do know. 6 of which belonged to her.
And all around the same time?
All around the time. She obviously didn't want to get off the phone because no one calls me 6 times in a row unless they need some help.
Can we continue to play from 138?
Go ahead.
Can you pause right there very quick?
Paused at 1 minute 47 seconds.
Do you see in this video your friend Miss Patterson walking back in the direction that she had just come from?
I see her on the phone talking to someone, which I assume would be me, telling me where
Mr.
she...
Kirby, I need you to answer the specific question that's being asked at the moment, okay?
All right.
Thank you.
Yes, I see her on White Rock on the phone walking back in the direction she was originally...
Again, Your Honor, I'm
coming
going to object
from.
to this line of questioning unless the defendant can put this witness there. I don't know what the relevance of this testimony is.
I didn't even get
The
to that
exhibit
point.
has been received, it's been published previously.
Absolutely.
So I'm gonna give Mr. Brooks some leeway here, overruled. I would like you to get to where you need to go, though.
That was the next question. At this point in the video, had you yet come into a range where you and your mutual friend Corey, had you yet come into a range where you can see Miss Patterson at that point?
Corey was the one that spotted her first.
Could you yourself see her at that point?
I heard her scream. That's what caught my attention.
And you made reference to that scream being heard from inside the vehicle. Would that be fair to say?
Yes, because that's where she was when she called me. And I was still on the phone with her while going down White Rock Avenue. Even while I was talking to the officer, I said, I'm on the phone with her right now. I'm trying to figure out where she is. Can you please call for backup? So we continued down White Rock to look for Miss Patterson.
Would it be fair to say that in the phone call you received, she told you where she was at, and that's the area that you were generally responding to with your mutual friend Corey?
Miss Patterson doesn't know Waukesha. I knew the area she was talking about because I live in that area.
Would it be fair to say that you just testified to when you had the interaction with law enforcement that you stated you're on the phone with her right now trying to figure out where she was? So would it be fair to say at that point you didn't know where she was?
I knew that she was on White Rock. I didn't know exactly where or how far down on White Rock she was at that point in time. At that specific time, I did not know. It wasn't until I seen a red SUV parked in front of the apartment buildings on White Rock that I figured that might be the one that she was in. It was Corey who spotted her across from the road.
We're paused at the 1 minute and 47 second mark of this video. it's a little hard to see houses and things of the like. Can you point out in what area the red apartments you're referring to might be?
It's a touch screen.
It's a touch screen,
Oh,
so
it
you
is?
can.
Yeah.
I don't know.
You can make an arrow point in the direction if that's helpful.
Not Google technology, guys. Sorry. I'm a dirt digger. Okay. This is the entrance. This is the entrance to White Rock Elementary. Across the street and up, maybe 20, 30 feet, there's an intersection leading from an apartment building to the White Rock campus. That would be up here in this general corner, right here. This whole area.
Would it be fair to say that from where we're paused at in the video, we can't tell if there's any vehicle parked in that general area?
You literally just played the video where the vehicle
Just
turned
answer the
around.
question, sir.
No, you cannot see it from this angle.
Can we please clear the
Yes.
arrow? Thank you. Would it be fair to say that where the video is paused now, that Ms. Patterson is not, or who you identified as Ms. Patterson is not inside of a vehicle?
She is not inside of a vehicle in this video, no.
Can we play it from 1 minute and 47 seconds?
Go ahead.
Pause there. At this point, had you come into a range where you can see Ms. Patterson at that point?
No.
The record video's paused at 2:13.
I'm sorry.
It's all right.
213.
Keep going.
And you made reference to your friend Corey spotting her first.
Yeah.
Is that correct?
Corey had said that she thought she had seen her across the street, and we looked, and we crossed the street once, and then we crossed the street back over. Then we crossed again for a final time. That wasn't until later when the incident with Mr. Brooks took place.
And at this point, walking with your friend Corey, had she alerted you to spotting Miss Patterson at that point?
She said she's over here. She must be out of his car now or something. She said something along the lines of that. So we went across the street and there was Miss Patterson hobbling down the street with a boot on her leg.
You made reference to your friend Corey saying she must be out of his car now. Do you know, as you were walking with your friend Corey, do you know if she observed Miss Patterson being in a vehicle at that point?
She was with me when the phone call came. So I assume that when someone tells me that they're in a vehicle, then they are in a vehicle. That does not mean that they would be in a vehicle by the time I got there. I was on foot. And I wasn't walking, I was running.
Can you play it from 2:13? Hard to see down in that corner.
Hold on, let it play.
Okay. Pause right there. Is that 409?
Yes.
Would it be fair to say we see some individuals walking right here? Are you able to see that in the video?
Yes, I can see it.
At that time, had you come close enough to the scene where you can observe any individuals in that area?
I don't remember the people that were in that area. I was only focused on the one, and that was the one in danger.
Could you
So no.
Could you at that point observe Miss Patterson?
From my point on the street, from where I was,
At that time, yeah, where it's paused at now.
during a parade, no.
Can we clear the circle? Thank you. We observed at some point Miss Patterson crossing over to the opposite side of the road.
Yes.
Did you see that?
Yes.
Any
I was
eye-
on the phone with her at that point.
Could you observe from coming down White Rock? Can you observe that from where you were at that time?
I was at the intersection of White Rock and Hartwell when she said that she was by some red apartment buildings.
Could you see her from that position?
No, not from that far down.
Can we play it from 409?
Go ahead.
Pause right there.
Pausing at 4:18.
418, I'm sorry.
Go ahead.
You see the two individuals here?
Yep,
Do you know who those individuals are?
that's me and Miss Corey.
So at 409 to 418, you were able to come into view of Miss Patterson at that point?
No. I wasn't. I was on my phone trying to call her back to find out where she was.
Can we clear this circle? Thank you. So at this point right here where the video is paused, 418, you weren't able to observe Miss Patterson on White Rock Avenue at that point?
Judge, ask and answer.
Huh?
Overruled, the witness may answer.
I was not looking ahead of me. As you can tell by the video, I was looking at my phone trying to call Miss Patterson back because she was not answering her phone. That scared me. So I told Corey to keep an eye out look for her as I tried to keep calling her. When I looked up and we got past the White Rock Elementary School sign, that was when I seen her.
Would it be fair to say that judging from the video, the White Rock, let me back up. Are you referring to the sign right here that says White Rock Campus?
I'm referring to where the end of the school building itself meets the driveway or the road that's there. There's a turnoff road.
I apologize. Can we take that X from next to the White Rock Campus sign? So can you point to exactly what you're referring to?
Where that intersection is, where I just drew that little X, that intersection cuts across from the other side of White Rock to the other side and leads to a road, but also there's the Frame Park area there, and I believe there's a boat launch there somewhere. I don't know.
And at that point, you were able to observe Miss Patterson.
I observed her walking when Corey had told me that she had seen her. And so we grabbed her and started to leave to turn around. At that point in time, an officer was coming to Frame Park because of the report that I had given.
So you observed Miss Patterson walking and not inside of a vehicle?
At that point in time, no.
No, as in
She was not in a vehicle at that point in time when we finally came upon her.
So when, if at any time did you observe Miss Patterson inside of a vehicle?
When she was going back into his vehicle to get her things or whatever it was that she was trying to pull out of his car, her phone or something or whatever.
Can we play the video from 418?
Go ahead.
Oh, I'm sorry. Can we clear the X?
Continuing to
Sorry
play
about
from
that.
4:18. It's at 4:21, but go ahead.
pause right here. Is it fair to say it stopped at 4 minutes and 38 seconds? Is it fair to say from the video that two people right there are crossing the road?
Yes.
And do you know the identity of those two people?
That's me and Miss Corey.
Would it be fair to say that at that time you observed Miss Patterson?
That was when I first noticed the red Jeep, or red SUV, whatever you want to call it, across the street. We had zigzagged up White Rock, going from one side to another looking for Erica. When we ended up on this side, the red SUV was parked in front of the apartment buildings. There was a tree here, and Miss Erica came from the passenger side of the vehicle around the back. That's when I heard her yell something. That's when I went over.
You made reference to Miss Patterson coming from around the vehicle?
Coming from the passenger side, so I had assumed that she had just gotten out of the vehicle.
Do you know that for sure?
If I didn't see her earlier when I was on White Rock, or a vehicle earlier on White Rock, how could I know?
Did you see her in the vehicle at that time?
I seen her come from around the vehicle. I am not actually sure if she was in the vehicle at that point in time.
Thank you.
I was just going by what she said over the phone.
Okay.
So my
understood.
assumption is that she was in a vehicle.
All right, next question.
If it pleases Your Honor, do we have a better view of this point in particular?
I don't know.
Maybe on Exhibit 3 might be a better view of this
If you have a
particular
specific spot to direct the state to, then I will have them do that, but
Can we view Exhibit 3?
do you have a specific spot to direct the state to on Exhibit 3?
I'm not sure. It's been, I don't know how long since we viewed that exhibit. I don't know how long it is.
I'm just reviewing my notes. If there's a specific spot that you recall, I might be able to direct the state to that. But you'll have to give me a little more information.
Okay. I think that's why I was stating about the length of the video. I'm pretty sure I would know the exact spot. I don't know how long that video is. It's towards the end of it. I know that for sure.
Can you ask your next question? You need to be able to tell the state with more specificity which part of which exhibit and at what point.
Well, I know the exhibit, the exhibit would be 3, and the spot, judging on the length of the exhibit, would be towards the end of the exhibit.
And you're sure it's Exhibit 3? Would be
That
Exhibit 4.
would be White Rock Door 1, correct?
That's my understanding. right, so we're done with this exhibit?
Yes.
All right, turn that off. Just, I'm gonna just ask the state to just preview to the parties. We'll see if we can find it quickly on exhibit 3.
Yes. So it's
Looks like it's 4.
about 4:14, a little over 4 minutes. So I would say around about the 3:30-ish mark, if that helps.
Well, we're gonna just show it to you and the state, and if it helps you, then you can ask this witness a question about it. Otherwise, we're gonna move on.
I would say take it back to about 3:15.
This is the footage, though, you're looking
Yes,
for?
this is the footage, yes.
Is that where you want to start?
Actually, let's go 3 minutes, exactly. This is definitely the video.
All right, this has previously been received. Why don't we watch it from this point forward and then ask your questions?
But before it's played,
Oh, don't hit that yet. Sorry. Turn it
wait
off.
for the jury.
Go ahead, tell me what you want to do. That was a mistake on our part. It's just
You
in
can
front
show
of
it.
you and the witness at the moment.
Yeah, that's fine right now.
Well, I don't want to have to play it twice for the jury. So if you're
Oh.
going to question him, let's show it. It's already been admitted.
So should it just publish
Why
now
don't
or
we
just?
publish it from this point, play it, and you can ask the witness questions regarding it, okay?
Okay.
All right, so it's at 3 minutes. It's play about 1 minute and 14 seconds to get from this point to the end.
So are we publishing or?
Yes, we'll publish
Okay.
now. Jury, if you can let me know when it's on the monitors in the jury box. That may take a little longer.
Do you right now it's paused at 3 minutes. Does looking at this video right now bring any recollection of that day back to you?
Yeah.
And using the touchscreen, can you identify, if you see yourself in this video, can you identify where you are?
I'm right here.
And can you identify who the other person is that's shown on the exhibit?
That's Miss Corey.
You can play from right
Let's
there.
clear that first and then
Oh,
play.
I'm sorry. Well, before we play, could you see from right there where you are? Can you see Miss Patterson, where her position is at that point?
No.
Can we play it from right there?
Go ahead.
Can we pause? It's fair to say that we can see you and Miss Corey running towards the area of the vehicle that just stopped. Is that
Yes.
fair to say?
Yes.
And where was Miss Patterson at this time, if you recall?
At that point in time, she had met up with Corey. Corey had walked ahead of me, and her and I were looking for her. I didn't see her right away. Corey did, and she just told me she's in a red car. So that's what we were looking for.
At that time, was Miss Patterson inside of the vehicle?
I do not recall. But what I do recall is the owner of the vehicle getting out of the vehicle, and that became my primary concern.
Just hold fast a little bit. We observed the two, you and Miss Corey running towards the area of the vehicle. Why such the urgency?
Miss Patterson is a mutual friend of ours. She said she was in trouble. I don't play around when people are in trouble.
Can we play it from, it's paused at 3 minutes and 8 seconds. Can we play a little bit of it from there?
Go ahead.
Pause right there. Can you see Miss Patterson? It's paused at 3 minutes and 11 seconds. Do you see Miss Patterson in this video? Where it's
Yes.
paused at right now?
Yes.
Is she inside the vehicle?
No, she is not.
Had you seen her before that?
Corey had spotted her, not me, before that. She did.
But it is fair to say that you're also in the area at
I
that
am
time, correct?
not in this general frame, no. I'm
Not
actually outside
not
of the frame.
not the video, but you are present on the scene. Would that
Oh,
be fair to
yes.
say?
Yes.
And what happened at this point, if you
At
recall?
this point, there was a physical altercation between Mr. Brooks and Miss Corey and Miss Erica. I was more worried about Miss Patterson being hurt, so I went for her to get her out of the way. I stepped between them as best I could, and I told Mr. Brooks he needs to leave. He needs to get out of here. Does not belong out here.
Do you recall if there was a knife involved at that time?
No, that is a miscommunication, and I will clarify that. The Monday...
Hold on, there's not a question yet.
Okay.
He'll ask the questions. I appreciate that, but just answer the questions that are asked at this point. Go ahead.
Did you at any point during this altercation, did you observe Miss Patterson get back into the vehicle at that point?
I observed her reaching into the vehicle for something. I don't know if she was grabbing a purse or something or whatnot, but she was grabbing something of her personal property out of the vehicle.
Did you observe
while
her?
this was going on?
Did you observe her get into the vehicle?
No.
Can we play it from 3 minutes and 11 seconds, please?
Go ahead.
Pause it right there. Did you see yourself come into the frame in this vehicle at that
Yes.
point? Would that be you there?
Yes.
It would be fair to say that you had some type of jacket on, or a black jacket?
At one point,
that
yes.
evening? What happened to your jacket at that point?
That jacket hit the ground as soon as Mr. Brooks started going for the two women.
So you threw the jacket off?
Mm-hmm.
Is that a yes?
Yes, ma'am.
Thank you.
And what was your reason for throwing the jacket off?
Well, if the court don't hate me for it, I'm just gonna say it's a good thing that there were two women in my way at that point in time.
And what do you mean by that?
That means when my jacket comes off, trouble's gonna happen. Especially if you're trying to assault a woman in front of me.
So that gesture was an aggressive gesture.
Oh, that was a completely focused gesture.
Well, you did make reference to, let me back up. Would it be fair to say that you just made reference to trouble following you throwing off your jacket?
No, not trouble following me.
Well, maybe that's the wrong way to put it, but
I'm
there would
confused
be
by your
trouble.
question.
Excuse me?
Can you rephrase your question?
Oh, I will. I'm sorry about that. You made reference to there being trouble when your jacket comes off. Is that fair to say?
Yes.
Would it be fair to say that that would be, or that could be, perceived as an aggressive gesture?
You mean as an...
Objection. Calls for speculation. How it's perceived calls for speculation.
Sustained as to the form of the question.
If you recall, who gave the report that there was a knife involved?
That was not put into a report. That was a miscommunication between me and an officer. I had been knifed earlier that week and had 12 stitches in one hand. I said, now I have a friend being assaulted and I need backup here. So when the police stopped and asked if there was a knife, I said, no, there was never any knife. I didn't have a knife. Miss Patterson, Miss Corey didn't have a knife. You didn't have a knife.
Did you get a chance to see the report that was taken by law enforcement from you?
Well, I'm the one. You mean, you're talking about when I was on White Rock going to Miss Patterson?
No. The day of November 2020, the day of November 22nd, 2021, you made reference already to being interviewed by a detective, correct?
Yes.
And had you, after that, seen that report from that day?
No.
And you stated that the reporting of the knife was a miscommunication, you
Yes.
referred to it as?
Yes.
Did you at any time tell law enforcement that there was a knife involved in the altercation?
No.
Do you know if your friend Corey told law enforcement that there was a knife involved in the altercation?
No, she did not.
Do you know if your friend Miss Patterson told any law enforcement that there was a knife involved in the altercation?
She did not as well. No.
And how long before the incident on November 21 of 2021 had you known Miss Patterson up until that point?
Probably maybe a week and a half, 2 weeks.
I want to back up to the phone call that you received from Miss Patterson.
Okay.
When she called you, did she give you a name of whoever may have been assaulting her?
She didn't have to. She was meeting one person that day, and I knew exactly who he was because she had showed me his picture and rap sheet prior. Her child's father, the father of their 15-year-old daughter, is who she was meeting up with that day. And I told her multiple times it's not a good idea. I have a bad feeling about this.
Do you recall stating, well, actually, you testified to that here today. Do you recall stating that you walked past the red SUV that was parked?
Yes.
Would it be fair to say from the two exhibit videos that we watched today that you in fact did not walk past any SUV?
I most definitely walked past an SUV that was red on White Rock Avenue. Whether or not it was your specific SUV, it was still a red SUV. Up until this point, knowing Miss Patterson, I didn't know anything about the father of her child. I didn't know anything about his background except for what she showed me over the phone. Anything about his vehicle description, why would she need to tell me that?
Is it fair to say that the video doesn't show you walking past any red SUV?
If the video,
Is that fair to say?
If the video proves that, then yes.
In the report that in the report that was taken from you by detective, do you yourself recall stating that the alleged defendant tried to punch and push you?
The alleged defendant being you? Yes. Attempted to.
Would it be fair to say from the video that it doesn't show you being pushed or?
No, it does not. It shows me pulling two women away from the situation.
Any reason why you would state to detectives that the alleged defendant attempted to punch and push you?
Probably because there were three different people's fists flying, and I was just trying to get the people that I cared about out of the way of danger. So if my statement to the detective is off a little bit after watching a bunch of people get run over, I can understand why.
So you were at the parade that day?
I was not at the parade that day. I was in the area
So
trying
how
to get back to my house.
So how can you watch people being run over if you weren't at the parade that day?
I wasn't attending the parade. I was in the area that the parade route was in. My street is the parade route.
Did you see anyone injured that day?
During
the parade?
Yes, after I walked back through that area,
You saw someone get injured?
I saw a red SUV take off like a bat out of hell down Main Street and go through a crowd of people.
The question was, did you see this take place?
With my own freaking eyes, yes. How many times do I have to say yes for you to understand it? YES spells yes.
I'm sorry, Your Honor, I don't know how to.
You moving to strike the last response?
Yeah.
The jury will disregard the last response. I'm just gonna remind both of you, please answer the questions that are asked. And follow-up needs to take place. Either Mr. Brooks or the state will ask.
Is it fair to, well, in reference to the Exhibit 3 video that we just viewed?
You're talking about the one by the elementary school?
Yeah, the one
Okay.
the one that we just viewed,
Just checking.
which would be Exhibit 3. Is it fair to say from that vehicle, got me?
Video.
I'm sorry. From that video, is it fair to say from that video that, in fact, there are not three people throwing punches? Would that be fair to say?
There are three people throwing hands in that video. Erica, Corey, and Mr. Brooks. Not myself. If you watch the video, you will see 3 pairs of hands go up towards one another. Whether one is stepping in to pull someone away from another or not, hands are being brought up.
Do you recall where you went after that altercation?
You mean where me and the 2 girls went? Where me and Miss Patterson and Miss Corey went?
Where you and
We
your 2
started.
friends went? Yes.
We started walking back. We turned to walk back the direction we had came, so taking White Rock to Main Street, and then cutting through the neighborhood there to get over to where the women's shelter was. That was where we were going at that point in time. However, things took a drastic turn when the red SUV that I have described multiple times went down the opposite direction of White Rock Avenue, across the railroad tracks and the intersection of Perkins and White Rock, and then turned back around and came back down. That is what you saw in the video here when the red vehicle pulled up on the school side of White Rock. After the altercation between Miss Patterson, Mr. Brooks, Miss Corey, and myself, the 3 of us, Miss Patterson, Miss Corey, we started to leave. I told Mr. Brooks, you need to get out of here. The police have been called. You need to leave. You need to leave now. You do not belong here. I did not expect.
Can you strike everything that's not pertaining to the question that was asked?
Actually, I'm just describing the entire event in its entirety.
I understand. I'll strike the response as being non-responsive to the question. The jury is to disregard it. Re-ask your question again.
Okay. Do you recall where you and your 2 female friends went after the altercation?
We started to head back in the direction of the women's shelter where they lived, where they were staying at the time.
Do you recall at any point during your travels to the women's shelter, as you referred to it, do you recall at any time coming into contact with another law enforcement officer?
Within that point in time, no. Except for the one that pulled out of Frame Park.
Do you recall at any time being stopped by a law enforcement officer on your way back to the women's shelter?
We were stopped partway down White Rock, and that was when I had told the officer, because he wouldn't get out of his SUV, I had let him know that they need to be on the lookout for a red SUV that took off back down White Rock towards Perkins Avenue, or street or road, whatever it is. The officer had asked me if there was someone with a knife, and that was when I held up my left hand, and I said no. I said I have 12 stitches from a knife injury on this hand, but this is what you need to be looking for, is this red SUV. And I'm guessing that's where the miscommunication of the knife came in, and I don't know where that officer went after that.
And would it be fair to say that that was the second law enforcement officer that you had spoke with that day at that time?
Yes. You are referring to November 21st?
Correct.
Okay.
During that interaction with the second law enforcement officer, do you yourself recall stating that a black guy just assaulted my friend?
No.
Any reason why the officer would report that?
Objection, calls for speculation.
Grounds.
Sustained. Calls for speculation.
Did you yourself sustain any injuries during the altercation?
I ripped open 3 stitches on my hand, but that was more so from pulling Miss Corey away from Mr. Brooks so we could get out of there.
Did you report to any law enforcement? Well, I guess that would refer to the second law enforcement officer that you spoke with. Did you report that to that officer?
No. Because at the time I didn't notice it. I didn't notice my hand was ripped open again until I got home.
So it would be fair to say that you don't know how those stitches opened up. Would that be fair to say?
No, I'm pretty sure I know how they opened. My stitches got caught on the zipper on Corey's backpack. That's how the stitches were ripped out of my hand when I was trying to pull her away from Mr. Brooks and intervene between her, Mr. Brooks, and Miss Patterson.
Knowing a little bit about stitches, would it be fair to say that a wound that was stitched being reopened would cause a little bit of pain? Would that be fair to say?
Objection, relevance.
Grounds.
Sustained. Relevance.
Did you notice any blood from the stitches being reopened?
Didn't feel anything until I actually looked at it when I got home. 12 stitches coming across my thumb in kind of like a fish hook type pattern. There was the 2 over here that ripped open and the 1 up here. Or actually, I take that back, the 1 up here.
So just for the record, he's holding his left hand. He had his thumb out, extended almost like an L, but with the other fingers almost like a C, and he was pointing to his left thumb near, I would say, the middle of the thumb, and then the curve of the thumb where on the inside where it goes up toward the index finger. Sorry, I have to make a
Now-
record of all.
No, that's fine.
Go ahead.
So was it 2 stitches that opened or 3?
Objection, relevance.
Grounds.
Overruled. He may answer, but then move on.
It was 3.
And do you recall what time you made it home that evening?
Absolutely not.
Was it immediately after the altercation or sometime after? Or
No, I took the girls back to the shelter, and then I started running back towards Main Street to try and see if I could avoid the parade traffic. And that's when I saw the red SUV go down Main Street.
And do you recall speaking with your women friends after you had made it home that evening?
Yes.
did at any time you indicate to them that you,
Objection, you're saying?
Hold on, let him finish the question. He was asking what he
strike
indicated to
the
them.
question? I thought that's what I said.
You can ask your question. That's what I thought you were saying too.
Did you yourself at any time indicate to your female friends that you had sustained injury during the altercation?
No.
Objection to relevance?
Overruled, his answer may stand.
In the time that you had known Miss Patterson up until that day of November 21st of 2021, had you yourself ever heard Miss Patterson refer to the alleged defendant by a different name?
Objection to relevance?
Grounds.
Overruled, the witness may answer if he knows.
No. You mean like an alias or something?
A different name.
Well, okay, that could, a nickname, an alias. I mean, let's be specific here.
Did Miss Patterson ever refer to him with another name, if you recall?
Not that I can personally recall, no, ma'am.
All right, thank you.
Do you recall if, to your knowledge, was your friend Miss Corey, as you referred to her, do you recall her stating that she was injured during the altercation?
She did tell me that she I believe she like hurt her finger or her fingernail or something like that, but I don't think it was relevant to the incident that had happened.
What do you mean by you don't think it was relevant to the incident that happened?
Objections to relevance?
Sustained is to the form of the question.
No further questions?
Before I decide whether to do cross at this time, how long do you believe it will be?
0 minutes because I have no cross.
All right, thank you. And you can step down, and we're gonna take a break.
Thank you, ma'am.
Give me a second. I'll rise for the jury. Let me excuse the jury for a second. All right, thank you. You may be seated. You may step down, sir. And I presume he may be released from his subpoena, Mr. Brooks? You're done questioning him?
Yeah, I don't think he's no longer needed.
All right, you are released from your subpoena, sir.
Thank you.
All right, let's take about a 15-minute break. Anything we need to address prior to that, or can we do it when we come back?
No, thank you.
All right, Mr. Brooks, work with the state, please, for the next witness. We have them available. We are back on the record. It's 3:58. Appearances are as they were before. Jury is coming into the courtroom.
Subject matter jurisdiction.
Your request, as I understand it, is noted. The objection is noted. It's overruled. We'll continue with the questioning of a witness. You may call your next witness as soon as all the jurors get in the jury box. All right, thank you. Please be seated. Go ahead, sir. You may call your next witness.
Defense calls Heather R. Reamer.
Thank you. Good afternoon, ma'am. If you would please make your way to the witness stand. When you get there, please remain standing. Raise your right hand. It is up a riser. Be mindful of that. And then my clerk, Teresa, is ready.
Do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Thank you, ma'am. Please have a seat. The first thing I will ask you to do is to state your first and last names for the record and then spell each.
Heather Reamer, Heather Riemer.
Thank you. Go ahead, sir, your witness.
Good afternoon, Ms. Reamer. How are you feeling today?
I'm okay.
I want to direct your attention to the evening of November 21st of 2021. Do you recall what you were doing that evening?
I was at the Waukesha Christmas parade.
And do you recall who you were with at the parade?
I was with my husband and 3 friends and 1 of their children.
About what time, if you recall, did you and your family arrive?
Right before it started, we were running late, and then by the time we got to where we were seated, it was right before it started. I don't recall exact time.
Do you recall where you and your family were positioned along the parade route that evening?
At the time, I don't remember, but I later found out that it was the Historical Society.
What do you recall weather-wise that evening? Was it a pretty chilly evening?
Yes.
If you recall?
Yes.
Pretty windy?
Yes.
So I'm assuming at some point you observed a bit of commotion. Would that be fair to say?
Yes.
And do you recall what that commotion was?
Everyone running around was the biggest commotion.
At that point, did the area you were positioned in get pretty loud, chaotic?
Yeah, screaming gets loud.
Do you remember what you and your family were doing directly prior to the parade that evening?
I don't recall.
At the point you observed this commotion, what did you do from that point?
started running.
I'm assuming with you and your family all took the same course of action.
We all ran, yes.
And where did you run to?
Away from the parade route. I'm not familiar with streets. I'm thinking it's East Avenue. We ran down that road.
Would that be a side street connected to the main parade route, or?
Yes, it was a perpendicular route.
Do you recall if that side street was barricaded in any way?
I don't recall.
Do you recall if there were any law enforcement officers stationed at that side street?
I don't recall.
Did you, at any time during the commotion when you and your family were at the parade, do you recall seeing anything that drew your attention in any way?
Yes.
And do you recall what that was that you saw?
A red Ford SUV driving through faster than all the other cars in the parade.
And what did you observe this vehicle doing at the time that it caught your attention?
It was honking. Well, I heard honking. I'm not positive if it was the red SUV or another car alerting.
Did you notice any other vehicles around the vehicle you saw, following the vehicle you saw?
Following, no. It passed a float that had a vehicle in the parade. So it was by another vehicle, yes.
And it was passing the other vehicle you're referring
Yes.
to, correct? And you stated a reference to honking. In your opinion, strictly your opinion, why would a vehicle honk its horn?
To alert somebody.
Do you recall I'm assuming at some point the vehicle passed the position where you were, would that be fair to say?
Yes.
At any time during the vehicle's passing you, did you see who was driving the vehicle?
No.
Did you notice if they were intense to the vehicle as far as windows?
Ma'am, can you speak up a bit?
Oh, I don't recall.
Thank you.
Do you recall if you were able to see into the vehicle?
I don't recall.
Do you recall if you got a chance to catch the license plate number of the vehicle?
No, I didn't.
And from your recollection, when the vehicle passed you, were the windows up or down?
I don't recall.
And did you at some time report what you saw to law enforcement that evening?
That evening, I did not, no.
Did you at any time report what you had saw that evening to law enforcement?
Yes.
And do you recall what agency that law enforcement officer was from?
I don't recall. I'm gonna assume Waukesha, but I don't recall.
And during the course of reporting what you saw, was it more of a recorded interview, or were they writing down what you were telling them?
I was on the phone, so I don't know what they were doing.
Okay. Do you recall if that was in the days following the incident or longer after that?
It was after the incident. I don't know how long after.
Upon arriving at the parade that evening with your family, did you notice any of the side streets barricaded in any way? Any of them?
Yes.
Do you recall if there were law enforcement officers at those barricaded side streets?
I don't recall.
Do you recall about how long the parade had been ongoing before you saw this vehicle?
I don't recall.
And from that point, did you and your family immediately leave the parade and head home, or?
We left. We didn't head home.
Did you or any of your family members suffer any injuries during this incident?
No.
At any time after the incident, do you recall seeing any news reports related to this incident?
Yes.
Did you keep up with those reports, or was it just that evening or the days?
Just a couple days within whatever was right immediately. I'm not a person to watch the news.
And after that initial phone conversation with law enforcement, did any more law enforcement officers follow up with you about the report?
No.
Did you yourself follow up with law enforcement after that
No.
initial report? Did you yourself observe the vehicle that passed you during the parade? Did you yourself witness anyone injured by the vehicle?
I don't believe so.
That's all I have right now.
Thank you. Any cross?
Yes, briefly. Thank you, Your Honor. Good afternoon, Ms. Reamer. Thank you for being here today.
Yes.
I'd like you to take a look at the man seated to my right, table to your left. Mr. Mr. Brooks. You ever seen that
Objection,
man
I don't
before?
consent to being called that name.
Noted, overruled.
Yes.
Tell us about when you've seen Mr. Brooks before.
Objection, leading.
It's cross-exam, so it's proper. They may lead. You may ask, you may answer.
As we were driving to the parade, we were coming to a stoplight and we saw the red SUV coming down the wrong way on the road, and I slowed down because the car in front of me started to back up to let him through.
This took place outside of a gas station, is that correct?
Yes.
Your Honor, I'd ask that we display for everybody exhibit number 7. It's previously been received and published.
Go ahead.
Objection to relevancy.
Exhibit 7 has previously been received. Overruled.
Is it relevant to this particular witness?
Yes, it is.
Am I publishing?
Yes, go ahead and publish, Madam Clerk.
Ms. Reamer, can you see the map depicted on the screen in front of you?
Yes.
We're looking at the intersection of North Street and Barstow Street. Does that look correct to you?
Yes.
And is this the gas station that we're talking about?
Correct.
And you were parked on North Street facing southwestbound at the time, is that right?
Objection, speculation.
Overruled. The witness may answer.
Is that the way of traffic? I don't know.
Well, let's
So-
assume, based on these arrows here,
Oh,
Objection, speculation.
yep.
They're on the map. Overruled. Her answer was yes, and you may ask the next question.
Madam Clerk, can we please clear the annotations? And you saw the red SUV that we've been talking about come the wrong way on North Street, is that right?
Correct.
And what happened after that?
Should I draw?
Sure, yep, that's a touchscreen, go for it.
So I stopped roughly back here, as the car that was here started to reverse this way.
Okay, can we please, let's get a screen grab of this, please, Your Honor, and mark it as Exhibit 7.
Where's my exhibit list?
It'll be C as in cat. Or Charlie.
C, Charlie, please.
It will be so marked. And just for the record, the green line was placed by Attorney Wichow from, as you're looking at the exhibit, left to right to demonstrate travel of a vehicle in his question. And then the witness put the yellow mark on the screen, and it will be received as 7C as in Charlie. Go ahead.
Objection to relevancy.
Overruled.
You saw Darrell Brooks driving that red SUV in front of that gas station, is that correct?
Objection,
At
I
that
don't
time, I
consent
didn't
to
know.
being called that name, and it's speculative.
Overruled. You may answer.
At that time, I didn't know his name, but yes.
But now that you see him sitting in court today,
Yes.
that's the guy.
Yes.
Objection, speculative.
Overruled. The record will reflect the identification of the defendant as the driver of the red SUV she saw as depicted in this exhibit.
Thank you. May we please display for everybody exhibit number 15, which has also previously been received and published.
Go ahead.
Can we zoom in, please, on the intersection of Main Street and Northeast Avenue?
Objection, relevancy.
I presume the question will provide the relevance, so go ahead.
Thank you. You were sitting in front of the Historical Society, you testified?
Yes.
And do you recognize this map in front of you?
Objection, speculative.
Overruled. The witness may answer.
No, I don't.
Okay. Would the Historical Society be near this intersection that I'm circling, East and Main?
Yes.
Okay, we can please remove that annotation, Madam Clerk. When you saw the red SUV drive by, you testified you could not see the driver, correct?
Correct.
Because it was going so fast?
Yes.
Did you ever see that SUV come to a stop at any point on Main Street?
No.
In fact, did you see it accelerate as it traveled towards more people?
Yes.
Objection, speculative.
It says, overruled. The witness may answer.
Sound
Yes.
like you was going to say substantial.
And then I remembered you had called the witness, not the state. So cross-examination is appropriate. Fair enough, though. Next question.
Did we get an answer on
I said yes.
that? Okay, thank you. That's all I have.
Redirect, sir.
Yes.
Do you want any of the exhibits up?
I forgot what the one was before this.
7.
7.
7 was the map with, the gas station. This is 15. I'm gonna turn it off until you tell me you need something.
I need exhibit 7.
All right, if the state would put that up and we'll publish it for the jury as well.
And when shown this exhibit on cross, you stated you were approximately around. As a matter of fact, that wouldn't be fair. Can you erase that that mark, please?
It's clear.
Were you show again where your vehicle was positioned?
It's just a rough estimate, but
Okay.
probably right about here.
And where we?
That's when I initially slowed down to stop.
Okay. And you stated there was another car that did a backing up motion. Can you show again where that vehicle was positioned?
If they were at the light going this way, backing up.
If you recall, or do you recall, if there were any vehicles in this space right here?
There was none.
Rough estimate, about how far would you estimate the distance is between your vehicle and the vehicle that was at the light? Rough estimate.
I never came to a complete stop back there. It's when I started to slow down.
So you were still kind of rolling forward a little bit?
Yes. Because they backed up and then moved forward, and so then I moved forward.
So
all the
you
way.
didn't come to a stop until you noticed that vehicle backing up?
No, I didn't come to a complete stop until we were back up at the light. I started to slow down at that point.
So where did you end up? I'm sorry, can you erase the white circle?
I can erase all of it or none of it?
The white circle.
Only, I think it's just all or nothing.
Oh, all. I'm sorry. So we'll start this again. Where did you finally come to a complete stop at, if you recall? And at that time, well, back up a little bit before I get to that. You observed an SUV, you say, at some point before you came to a complete stop?
Yes.
And what did you see that vehicle do?
Drive this way.
What did you see it do after you noticed that it was coming in that direction?
Turn in here.
Would that be into the gas station?
Yes.
And what did you see the vehicle do at that point?
Roll down their window and yell something at the car in front of me.
Did it stop?
Yes.
Was it? I'm assuming you might know what I mean by this. Was it like a brake stop or was it a park stop? If you recall.
If you're not in the vehicle, how do you know that they're put it in park?
Well, brake stop would be brake lights, but okay.
Objection, move to strike.
Grant that, strike the last statement made by the defendant, but you may ask your next question.
And how long were you at the light?
Just a very short time. It turned green pretty quickly.
And in that short time, you were able to see who was driving the vehicle, the SUV, as you say, that went into the gas station.
Yes.
Is that the same SUV you saw at the parade that evening?
Yes.
The same vehicle that you said you don't recall if it was tinted or not?
Yes.
So at the point of seeing this vehicle at the gas station, at that point, did you notice any tints?
I don't recall.
Did you notice if there was anyone else in the vehicle at that time?
I only saw one person.
Could you see into the back of the vehicle?
I don't recall.
Can you see the passenger seat of the vehicle?
Yes.
Was anybody in the passenger seat?
No.
But you don't know for sure about the back seat.
No, I couldn't see it.
Can we take down this Exhibit 7?
Go ahead.
Can you pull up Exhibit 15? Can we pull that back up?
The state would please pull that up. We'll publish that for everyone.
And,
Hold on, let's make sure the jury has it.
oh, I'm sorry.
Okay, thank you. No problem, go ahead.
And you stated that you were in front of the Historical Society.
Correct.
And if I recall, you can correct me if I'm wrong, that would be somewhere around this area here.
Yes.
Sir,
Can
was
we,
that a yes?
Yes.
Okay, thank
Can
you.
we erase that, that white? So the side streets, I'm sorry, I didn't mean to tap the screen. Can you erase that? I'm sorry. The side streets would be Buckley Street and Northeast Avenue. Would that be fair to say by looking at the map?
Yes, that's what the map shows.
And you said you don't recall if those side streets were barricaded.
I wasn't at the intersection. The Historical Society is at that intersection, but I was in front of the Historical Society.
So would it be fair to say you were close to the side street?
I was close, but not at it, so I don't know if there was barricades there. I wasn't close enough to see to be by barricades.
So you stated you ran away from the commotion, so it would be fair to say at some point you moved from your position in front of the Historical Society, correct?
Correct.
And do you recall what side street you went down to when you were running?
We ran up to the building of the Historical Society on the side of East Avenue.
We can, what, just really quick, so that would be this side street here.
Yes.
We could take down exhibit, is it 15? And you stated that you knew the identification of the driver of this SUV based on what you observed at the gas station, correct?
Can you repeat that?
You stated that you, let me back up. You were able to identify the driver of this SUV based on what you observed at the gas station, correct?
The gas station, I saw the driver, yes.
Do you recall what the driver was wearing when you observed him at the gas station?
At the gas station, no.
Do you yourself recall in your telephone conversation with law enforcement stating that the driver was wearing a red-orange shirt?
That was not from the gas station.
So where would that description come from, if not the gas station?
I saw video footage of you in somebody's backyard.
So what did you observe the driver of the vehicle wearing at the gas station?
I don't recall.
So it'd be fair to say that in your phone conversation with law enforcement, you gave a description based on what you had seen from footage. I guess that would be the right word to use.
The shirt color, but your description was from the face was from the gas station.
And do you recall in that phone interview stating that you weren't positive on the shirt color?
Yes.
Do you recall in that phone interview stating that since seeing the news that you may be getting the clothing description incorrect?
I remember saying that I've seen the news. I don't remember saying that that is why I'm getting it. It wasn't the same as when you were driving.
So would it be fair to say that your description came from watching footage at some point and from news reports at some point?
Not news reports.
But you did see this incident reported on the news?
Yes.
Did you see where the vehicle went when it passed your position?
Objection, can we just clarify whether that's at the gas station or the parade?
Fair enough. Sustained.
Sorry for that, I'll clarify.
Thank you.
Do you recall seeing where the vehicle went when it passed your position at the parade that evening?
Continued down the parade route.
And you already stated that during the parade, seeing the vehicle and not seeing the driver, how are you sure that that driver of the vehicle you saw at the gas station was the same vehicle at the parade?
I know that they were both red SUVs, Ford SUVs.
Were you yourself sure that they were the same vehicle?
They were the same model, same color, same make.
So what is the make and model, if you recall, of the vehicle that you saw at the gas station?
Ford Escape.
And how did you come to that determination based on your observation at the gas station?
Because I know a decent amount of cars.
by decent?
I mean, I don't know all makes, but I know this one for sure because I had a friend that had the same exact make and model, just different color.
So are you yourself able to just look at a vehicle and tell the make and model?
Some, yes.
So it'd be fair to say some, not all.
Correct.
So that brings me back to the driver. You stated you didn't see the driver of the vehicle you saw at the parade. How do you know there was the same driver?
Objection. The state's the evidence. She never testified that she knows it's the same driver.
Sustained.
I'm asking how did you...
Rephrase your question, please.
Do you know if it was the same driver?
No.
No further questions?
All right, thank you. You may step down. And you are excused from your subpoena. It is 4:34, so we will end for the day. And I will read my instructions to you. The jury, once again, do not begin your deliberations and discussion of the case until all the evidence is presented, and I have instructed you on the law. Do not discuss this case among yourselves or with anyone else until your final deliberations in the jury room. This order is not limited to face-to-face conversations. It also extends to all forms of electronic communications. Do not use any electronic devices such as a mobile phone or computer, text or instant messaging, or social networking sites to send or receive any information about this case or your experience as a juror. If you come in contact with the parties, lawyers, interpreters, or witnesses, do not speak with them. For their part, the parties, lawyers, interpreters, and witnesses will not contact or speak with the jurors. Do not listen to any conversation about this case. Do not research any information that you personally think might be helpful to you in understanding the issues presented. Do not investigate this case on your own or visit the scene, either in person or by electronic means. Do not read any newspaper reports or listen to any news reports on radio, television, over the internet, or any other electronic application or tool about this trial. Do not consult dictionaries, computers, electronic applications, social media, the internet, or other reference materials for additional information. Do not seek information regarding the public records of any party or witness in this case. Any information you obtain outside the courtroom could be misleading, inaccurate, or incomplete. Relying on this information is unfair because the parties would not have the opportunity to refute, explain, or correct it. Do not communicate with anyone about this trial or your experience as a juror while you are serving on this jury. Do not use a computer, cell phone, or other electronic device, including personal wearable electronics, applications, or tools with communication capabilities to send any information about this case. For example, do not communicate by telephone, blog post, email message, text message, instant message, social media post, or in any other way on or off the computer. Do not permit anyone to communicate with you about this matter, either in person, electronically, or by any other means. I appreciate that it is tempting when you go home in the evening to discuss this case with another member of your household, but you may not do so. This case must be decided by you, the jurors, based on the evidence presented in the courtroom. People not serving on this jury have not heard the evidence, and it is improper for them to influence your deliberations and decision in this case. After this trial is completed, you are free to communicate with anyone in any manner. These rules are intended to assure that jurors remain impartial throughout the trial. If any juror has any reason to believe that another juror has violated these rules, you should report that to me. If jurors do not comply with these rules, it could result in a new trial involving additional time and significant expense to the parties and the taxpayers. You are to decide the case solely on the evidence offered and received at trial. With that, we'll see you all tomorrow morning. We'll begin at 8:30. All rise for the jury. Thank you. Be seated. I know, Mr. Brooks, I think you wanted to make a more full record just regarding the timing of that last witness. I'm not going to put all of the details on the record. We made a record in closed session just due to a privacy issue related to that witness. And I required you essentially to call that witness out of the preferred order that you had given her availability. I believe you wanted to put on the record the information you initially had from Attorney Opper was general about her unavailability on Friday, which was the day, as I understand, that you preferred to call her, and more information was provided today. I don't want to get into the specifics, but would that be a fair characterization of kind of the discussion we had outside the presence of the public?
Yeah, that's fair.
Anything you want to add to that?
Nah, just, it pretty much sums it up.
Okay, good. So,
I felt that it would be, thinking about it as everything was happening so fast, I was just like, yeah, it probably would be best to, take the procedure that she's having into account, because it could be.
I don't want to go into that while we're still in the public record.
Right.
All right, due to her privacy rights. But I appreciate your understanding with that and calling her. I did require you to call her out of order, but I appreciate your understanding and of that. I don't think there's anything else I need to cover at this time, unless there's something from either one of the parties. From the state first?
No, but we would like some further direction from the defendant as to who he wants here tomorrow morning and tomorrow afternoon, if he wants us just to continue that list that he originally provided, or if there's an update. And we could do that off the record, Your Honor. I don't know that we need you involved, but.
Okay, thank you. Then hopefully the parties can figure that out without me needing to be involved further, but anything from you, sir?
No, I'm just gonna say with that, I'm not gonna put them in specific order.
Not looking for the order, but we're behind given the timetable and the understanding between, as I understand it, between you and the state.
State has the list.
So generally speaking, you've been taking about a half an hour, I would say, for each witness. At least that one took about 35 minutes. If we go on that schedule, do you think, understanding we take a mid-morning break, a lunch break, and a mid-afternoon break, I would think we could get through at least 3 to 4 tomorrow morning and 3 to 4 in the afternoon. I'm gonna have the parties be available for that and be ready for that. Whatever order, but
All the parties?
yes, both you and the state.
So at this point, there's no telling what witnesses will be here tomorrow, right?
Well, based on the groupings that you gave to the state, it sounds like we got through only one from each
Right.
kind of category. So we'll go back to the first would have been Thursday morning. You need to call the rest of Thursday morning. Was there 2 left
Right.
of that?
Yes, correct.
So
And so let's do Thursday morning and Thursday afternoon. The people you designated, I'm going to direct the state to have here tomorrow morning. That's 4 witnesses, whatever order of those 4.
5. It's 5, but yes.
It's 5?
We'll have them here,
Um,
based on your original list.
And then, how many does that leave? Because I'm not
that's what I'm trying to
doing
figure out.
good with math this
4.
late in the day. 4, so 4 in the afternoon then. So our hope is to get through all your witnesses
I can say this
tomorrow.
for the record. One witness I intend to call tomorrow is not going to be 35 minutes.
Fair enough. Do you plan to call that person in the morning or the afternoon?
I'm leaning towards the afternoon. That could change depending on the flow of the morning, I would guess. If the morning goes pretty.
Can you tell me which list they were on when you gave it to the state? Was it Thursday afternoon, Friday morning, or Friday afternoon?
I didn't put them on days, but I believe they were in the maybe the second floor names. If
Do you just
that
want to tell me who
helps.
it is so we can prepare, so that person is told to come in the afternoon rather than wait through the morning?
I don't want to say who it is.
Well, I want the person to be here when we're ready to go, but
They were here today, if that helps.
Yeah, I know who it is. It's Erica Patterson, Your Honor. There's no
Maybe.
mystery here.
Maybe
all right,
it is,
that's
maybe
what I
it isn't.
would have. That's kind of who I thought it would be as well.
So,
I'm gonna have her come tomorrow afternoon. Then I'm
okay,
not
we
gonna
will
have
have
her
you
come in
here
the
at
morning.
1 o'clock tomorrow afternoon. Your
So
Honor.
we
Thank
need to be
you.
mindful of people's schedules.
Thank you. We'll have everyone else here at
That's
8:30.
interesting because what if that was not who I was referring to?
Then you need to tell me right now so I can make an alteration to that.
Come on, Judge.
Sir, we're at the end of the 3rd week of trial.
So
I
can we
need
at
to
least
keep
be
this
fair?
moving
Can we at
along.
least be fair and say that's not due to me though?
That would not be fair to say.
How?
It's
How? The state said that they needed 5 to 7 business days to present their case. Did they or did they not say that on the record?
and there's
So how
it doesn't
did
matter how we got there at this point. I'm trying
Then they
my
need to chop,
darndest
chop.
to get all
It
the
should've been
witnesses
chop, chop.
done. So I'm directing the state to have Miss Patterson come tomorrow afternoon.
If that's
And the
what I was
other
referring to, which
witnesses?
I wasn't, but everybody think they know what I'm thinking.
Then you need to tell them if it's someone else, and if you want her here in the morning.
I'll
then
say
that-
this. Everybody that was here today that didn't get called, have them here tomorrow. So that'd be 1, 2, 3, 4, 5 people.
And you need to tell me who you want in the morning, not by the order, and who you want for the afternoon. Otherwise, I'm gonna make the order that I just made.
No, how you gonna make the order for me?
Under 90611, sir.
No, you can't. I can call. I have the right to call them in the order that the state didn't have to have an order. And I'm guessing
No, but the
Correct me if
state's
I'm wrong, but
helping
I'm-
you out in terms of the order,
they were helping me out with serving
and
the
they're helping you.
subpoenas. Not the
So,
order of how I would call the witnesses, but the subpoenas. And I gave the state.
do you want to be responsible for calling each person tonight and telling them what time they need to be here? Or should we let the
See,
state
here we
do
go
that?
with this again. There's something that's impossible to do.
That's not true. You have
How's it
access
not
to
true?
a phone.
So somebody's gonna answer a collect call from someone they don't even know. Nobody in this courtroom will answer a collect call and pay for a phone call from
That's
somebody
not my
that you do not
understanding of
know.
how it works at the jail, that you can, that
Yes.
there's other means to make phone calls.
There is no other way to utilize the phone.
Well, maybe I'm wrong on that, but be that as it may, the state is helping you out. This is to make tomorrow go as smoothly as possible, to be effective, to be efficient, and to use all of our time wisely.
Your Honor, with all respect, I did what was asked of me to do. I provided them with the list of the witnesses that I will call. And I stated before that I would not put them in order, and the state accepted the list that I gave them. So why, at this point, is
Who are
everything
the witnesses who are here
being
today?
a problem?
Douglas Kohler, Detective Guth, Erica Patterson, Christopher Bertram, and Jason Hayes were here today, in addition to Miss Reimer. Miss Reimer's now done. Nicholas Kirby was also here today. He's done. If we are going to continue to assist Mr. Brooks in getting these witnesses here, we need to have a reasonable time schedule. These witnesses don't just show up by the tooth fairy. We have to communicate with them. They have jobs, they have families. I've explained this 3 times to Mr. Brooks. If he wants our assistance,
Objection. She can chill with all
He
that. She can
needs
chill with all that
to-
tone.
hold on,
because
hold on.
we
I know
can get
it-
on that if that's what it is.
Hey, I
We
know
can
it's been a
definitely
long
get on
day.
that.
Let's keep this civil.
That's what I'm trying to do, but
So
she gonna have to tone it down.
I think both of the parties are getting a little
For real.
frustrated. I'm getting frustrated. So,
don't even
Kohler,
know who they be
Guth,
denying.
Hayes, Patterson. I missed a 5th.
Bertram.
Guth is a police officer, right?
Yes.
I know who Eric Patterson is. How about Kohler, Hayes, and Bertram? Were those
They were-
citizens?
They're citizens that relate to the parade, I believe, and post-parade. Not the DV.
It seems to me that even with one of the witnesses taking more than 35 minutes, that doesn't fill up the whole day. So we need to have some other people on that list for the afternoon.
So I will just continue to work in the order of the list that was provided. Your Honor, I think that's the only reasonable thing we can do at this point. Or we can do it alphabetical, or we can do it by random lot, because I don't know really what else to do.
By the list that was given.
What was the order of the list that you were given?
The first three were Kirby, Kohler, and Guth. The next line has three names: Patterson, Bertram, Hayes. The third line has three names: Reimer, Aldrich, and Lescano. The last list has two names and then also reads the state of Wisconsin.
First three people on the list you need to advise to be here tomorrow at 8:30.
Okay?
The next two people tomorrow at 10:30. The next two people after that tomorrow at 1:30. The next two people from there at 3:30. And then do I have anyone left over from there?
No,
Yeah.
One more?
no.
If I have to go late tomorrow, then I would say the last person can be at 4:30 if need be.
Yeah, I agree. We would very much like to get through the defense witnesses tomorrow, Your Honor.
I don't know if that's gonna happen.
Well, that's the order that I'm making in terms of the times people need to show up. That gives you a range of people to select from.
I'm gonna have to see that, what you're referring to then, because
Oh, I trust you wrote it down because that's what I did.
I
So
didn't. I
we
didn't
are at
write it down.
recess then for the evening. We'll see everyone tomorrow at
all right.
8:30 a.m.
So if
Thank
they
you,
don't get
everyone.
called like that, don't try to blame it on me.